Yes. I beg to mention item number 62, my lord. 62. Some difficulty today of in a council. I have taken the consent of the full time.
The court matter.
Yes, my lord. In fact, your lordship has
Same.
heard at length also, my lord.
Advised informed.
Yes, yes.
When do you fix?
But I had asked Mr. Kolita, in the first week he has some difficulty, my lord. He may be out of station next week. So in the second week of September, my lord.
The date put it.
Yes, yes, my lord.
The prayer for adjournment has been made on behalf of petition. Consider that matter of this matter here. No adjournment done. Matter is directed for hearing on
September sometime, my lord.
what
14th,
about 30th of 31st of August?
Mr. Kolita has some difficulty. Otherwise,
September first week, I 30 have.
yes,
We can have it on 7th of September. 7th September.
my lord.
7th.
My lord, I beg to mention item number 4, my lord.
4 years.
I may be allowed to withdraw.
Right. Your man Ahmed.
Yes.
Man Ahmed done it now for the petition. Submit that he has struck not to press. Union Vidya.
Obliged, my lord.
Lordship, I am appearing on behalf of Indian Oil Corporation.
Union Vidya. What is UI? Any CCC? Anyone CCC?
Lordship, my
Madam?
G. Swami.
Huh? Yes.
G. Swami.
You are sending out.
Yes, Lord. On behalf of A. Sharma, maybe.
G. Swami. Understanding. Getting on instruction of A. Sharma. Sending on trials. It's also a party. It's a party.
No, my lord.
Preparation according to
Yeah, please, Your Lordship. Your Lordship, I beg to mention for listing of orders of WPC number 3368 of 2014. Your Lordship, yeah, Your Lordship may kindly list it on 30th of this month. Nice, Your Lordship.
Yes, Mr.
My lord, there is a spirit from 8 to 44, my lord.
Yes.
My lord, we are supposed to file, the chief secretary was supposed to file an affidavit, my lord.
Yes.
I have received a communication, my lord. These are series of matter regarding the compensation appointment. All my senior friends are here, my lord. So, my lord, we are seeking some time. The chief secretary's office has informed me in a written communication that they are going from the phase of meetings, my lord. So, some 20 plus departments are involved. So, they need little time for that. So, we are seeking adjournment. I have
Because
informed
you are one of the petitioners.
Yes. They are all, my lord. So, my lord.
They are for government submit that in this series of cases which pertain to appointment or compensation ground, an affidavit was directed
By the chief secretary.
by the chief secretary. However, since many departments are involved, God has prayed for some more time to finalize and file the also has been announced for the when
My lord, let the matter come after 4 weeks.
the date
My lord will fix it.
this on it will be on 18th of September. We have more than 18th
My
of
lord,
September.
my lord, deeply obliged.
18th. Yes.
May I please be Lordship?
We can have this apart.
Please, your lordship, I beg to mention an item for listing bearing WPC number 5299 of 2022.
Two. What's the
Lordship.
matter about?
A promotion, lordship, of forest guards.
What's the stage of
Lordship, they haven't received their promotion.
what's the stage of the
Admission. First week of
next week? On first.
First.
September.
March.
May I please your lordship? Lordship, I beg to mention for listing of a regular second appeal, lordship 2014.
Today we are in bench three.
Lordship, I've mentioned as per the roster, your lordship.
That's three we've been adopted.
Oblige, sir.
May I please, your lordship, I beg to mention here in the for item number 53. We filed affidavit in reply yesterday. So with your permission, record can be called.
Yes. Thank you for request. Yes, ma'am.
Lordship, I beg to mention item 12.
Well, yes, but
As my senior is not well,
this matter we have adjourned. 18. 12 is a part of the system.
Yes.
18.
18/9.
Please, your lordship. Lordship, I beg to mention item number 42.
Yes.
As my case is not reflected in the main case, lordship. In item number 8 on last day. Maybe
42.
yes, lordship. Can maybe make a part of the same in the main case.
The part of the series only. What's the name of the petitioner? Sentiment is here.
Yes, sir.
The part of the series.
Yes.
It's not connected to completion of the part.
Yes, lordship.
69. Yes, what is it?
Lordship, basically they're talking about parity of penalty in the sense that one person has been exonerated. There's a Tada case in which many people were there. One has been exonerated, all have been exonerated, but disciplinary proceeding has been filed against two, and one again it has not been proceeded. So the two people against whom disciplinary proceeding is there, they are saying that this person has been exonerated in Tada, and as well as nothing has been done against him. So that's why we should also be held to be innocent and exonerated of all the charges in the disciplinary proceeding. In our affidavit, we have filed. We have seen that the person has been proceeded against. The third person we are talking about, your lordship, and he has later on it has been decided not to go with the penalty. And against the other two people, first there is with petitioner number 2, there is a proceeding. With petitioner number 1, there is simply a discharge order, your lordship. Simple single line discharge order, your lordship.
Is it the part of the
No, they have not challenged it on the ground that this is a simple discharge order. This should have been.
What has been challenged? Education.
No, they are challenging the discharge in both the cases, but in the case of petitioner number 2, it's just a single page, single line order in page number 10, your lordship.
What is it?
Lordship?
What? There are two petitions.
There are two petitioners. Petitioner number 2, page number 10 of the petition, it's a simple discharge order, your lordship. It's discharged from service with effect from 31/3/96, being unfit for retention in the post.
10. Page 10.
Page 10, your.
But why effect of 31/96? This is an order of 94.
No, it's lordship. No, the type copy, your lordship will see possibly it is 94. Maybe
Not
the type
96.
copy is wrong. It both is 94, your lordship.
Or 31/96. And for the first petition,
Petitioner, your lordship will turn to page number 12. This is the first show cause notice, and basically a disciplinary proceeding has been held against
it's 12.
page 12. That is the first show cause notice.
And what happened?
Then your lordship, disciplinary proceeding held till it reached the appellate state, and then ultimately appeal was also rejected. He has been discharged, your lordship, dismissed.
What
Lordship.
petition number 1 has been dismissed after DP.
Your Lordship. That your Lordship will find in page number 14, the penalty order, your Lordship. Remove, don't dismiss, remove dealing with so and so with immediate effect.
Page 14.
1-4, your Lordship. This is the operative portion, the last paragraph is the operative portion.
There is no procedure left yet to take the cause.
Yes, second show cause, then appeal, inquiry, second show cause, then appeal has also been filed. Appeal has also been rejected, your Lord. Their main thrust is that the third person has been completely, there's nothing has been done against with the third person, who was also part of the same Tada case. That's why they also deserve to be exonerated. And
Page 30. There were
name has been reflected, your Lord.
cabinet book. Both 1 and 4 connected.
No, not connected.
We have it. But you may not enter the match.
But there's another issue here, your Lordship. Here, the lower court record of the Tata case has been called. Whether the, because in that case, if the matter will be different, your Lordship, whether the record will be necessary, your Lordship, because the discipline.
For the time being,
All right.
try to inform the earlier.
This matter, my lord, I am having to step into the shoes of the great Mr. Niloy. So I hope I am able to do justice to the matter. Otherwise, it's a very short matter. And the petitioner has otherwise retired from service way back in 2011. The issue is like this, madam. He was a Assam Civil Service officer. He is claiming promotion from senior grade 2 to senior grade 1. And if the petition is allowed, he will be entitled to a little bit of financial benefit. And if your lordship will first have page 30.
Lordship, in this case, this is item number 2, your Lordship. In this case, the person has retired. Earlier, because of the Supreme Court cases, the promotion process was stayed. Thereafter, it was initiated, your Lordship. In 2008, 9, and 10 promotional process. So it was stayed by the Supreme Court. Then it was the seniority list was recast, and thereafter the promotional process was started, and then they filled up the vacancy, giving retrospective benefit. But for the thereafter, the process for the 2011 year, the promotion process was held on 27/3/2012. By that time, the petitioner retired, and by that time, the decision has been taken that there will be no retrospective promotion, because it was done only for that special case for these 3 years. And by the time, since the person has retired, therefore his case was not considered, your Lord, for promotion. So that is what they are seeking, your Lord, that they should be given promotion from that date when the DPC had said, even though he has retired, by giving retrospective benefit, and then they will get some notional benefit.
Can take this for final.
Yes, ma'am. It's a very short, otherwise the facts are in a very, very narrow. Your lordship will first come to page 33. Ma'am. This will indicate the fact that there were 23 vacancies in existence for the year 2000. Page 33. Ma'am. This is an agenda note that was prepared for placing it before the selection committee. This is, well, there's no date as such. This was just a note prepared for being placed before the selection committee. Your Lordship will kindly come to para 2 thereof. At page 33. The promotion selection of officers to senior grade 1 of the SES is made for the year 2011 and 12. The present vacancy of the posts in senior grade 1 of the SES are as follows. 2011, 23 posts.
Yes.
Now, if your Lordship will first come to the gradation list, which was prepared way back in 2002, I just want to indicate my position. Your Lordship will find this at page 41. Page 41.
Very simple.
The enclosed gradation list of ACS officers revised in pursuance of OM number so-and-so dated so-and-so in the context of the 85th Amendment, etc., etc. Now, if your Lordship turns the page, your Lordship will find the actual gradation list. It starts at page 42 and we are concerned with page 51. I just wanted to indicate my position vis-a-vis one of the persons,
51.
page 50.
No, your position is 51.
No, my position is at serial number 242. This was in 2002.
Which page?
Page 50. 5. Your Lordship will find my name,
Serial number.
242,
What's your name?
Bolindra Pran Kakoti. And your Lordship will also note the person at serial number 244, Mohammad Parvez Shah. This I am showing to your Lordship to demonstrate that this junior person got the promotion against these vacancies.
You belong to General Secretary.
Mal. Now, your Lordship will kindly make a note of my date of retirement also. Mal.
The Parvez is promoted.
Parvez, I'll come to that. Mal.
Yes.
I retired on 31/10/2011.
Yeah.
Retired. Now, if your Lordship kindly comes to page 30, 30,
Please.
Your Lordship will find only because they did not follow the mandate of the rules, which I'll come to a little later, madam. I want to show that this is the people in the zone of consideration for these 23 posts. Page 30. Your Lordship is aware it has to be 4 times the number of vacancies. Now, when the cases were actually taken up for consideration, these were the officers in the zone of consideration. And your Lordship will find Parvez Shah at serial number 19. So,
Where are you?
I am not there because I have retired. I got ousted. Because they, instead of doing it, as your Lordship is aware, the rules envisage a position that you will make an assessment of the number of vacancies. I'll come to the rule. You will make an assessment of the number of vacancies in the previous year and conduct the selection.
At the end of
Yes, I'll come to the rule.
the end of
End of the previous. Now, had they followed the mandate, there are judgments, my lord, I'll come to that also. Had this delay not been caused,
what is the criteria?
merit with due regard to seniority. Now, had they not delayed it till 2012, my position would have been at serial number 19 instead of Parvez Shah. Now, after this selection process was conducted, The order of promotion that is issued is at page 85. Page 80.
Section 9.
Annex 9. Your lordship will find the name of Parvesh Shah at serial number 12. Although there were 23 vacancies, for whatever reason, only 12 were promoted at that stage. Even otherwise, my lord, my name would have come in. That is what I wanted to indicate to your lordship. Now, there's another important aspect that I must bring to your lordship's notice. Now, there was a delay in conduct of the selection pertaining to the year 2010 also. And how they dealt with the situation is at page 37. 37. This is the minutes of the selection committee proceedings. They considered cases for promotion for the year 2009 and also 2010. If your lordship kindly turns to page 38, your lordship will find the proceedings pertaining to the year 2010. Towards the bottom of that page, your lordship will find promotion from senior grade 2 to senior grade 1 of ACS for the year 2010. And if your lordship kindly turns the page,
Yes.
If your lordship kindly turns over to page 39, your lordship has noted that the date on which the selection committee met was 8/9/2011, which is reflected from page 37.
Yes.
And if your lordship kindly sees page 39, in the third paragraph in that, there's a paragraph starting the board decided. It's a very long paragraph. I'm not troubling your lordship. I'm just pointing out the relevant portion. Towards the bottom, your lordship will find there's a reference to Assam Civil Service Rules 1998 in that paragraph. After that, recommended the following 34 ACS officers in order of preference for promotion to the senior grade 1 of ACS with effect from 1/6/2010. So, although the selection was actually held on 8/9/2011, they are giving retrospective effect, and your lordship will kindly take note of 3 names, my lord. The person has serial number 7.
Yes.
Serial number 7, there is one Krishna Ram Mili.
Yes.
He is recommended for promotion. He had retired long before. Then serial number 15, Munibur Rahman, another retired person. Serial number 15, Munibur Rahman. And then serial number 17, Hemanta Kumar Boddo. All these 3 persons on the date of the selection had all retired. Your lordship is aware, my lord, the logic behind this is why these retired persons were considered was for the simple reason that the mandate of the rules is that you do it year-wise. And had it been done on time, these persons would have been in service and they would have been entitled to the benefit. And accordingly, they not only are they recommended, the actual order of promotion is at page 35. Even while notifying the promotions, they do it year-wise. The top portion is for 2009. The second portion is for 2010. The following ACS will kindly come to this second portion. The following ACS senior grade 2 officers are promoted and allowed to officiate in the senior grade 1 of ACS in the pay scale of so-and-so with effect from 1/6/2010. And this is an order of 29th of December 2011. And your lordship will find these three names. Krishnaram Mili is at serial number 6. Munibur Rahman is at serial number 13. And Hemanto Kumar Vaddo is at serial number 15. And these three persons, my lord, my specific instruction is their respective dates of retirement where, my lord, if your lordship so desires, I can give the dates also. Para 6 months. That the petitioner begs to state that the respondent authorities might not have considered the name of the petitioner as he had already retired from the. I'm sorry, Madam. Well, the specific, this thing is, I have made annexed these documents. The fact that they had retired is towards the bottom of that first subparagraph. Zone of consideration for promotion from senior grade 2 to senior grade 1 who were retired before the publishing of the selection. Yes. Para 6 towards the page 5 one, towards the bottom of the first subparagraph. These three persons, my lord, specifically.
Is there any
Yes, my lord. Towards yes, my lord. The second subparagraph, my lord.
in the promotion orders that they had?
My lord, this second subparagraph of para 6 one. The petitioner further begs to state that earlier on many occasions, the respondent authorities had failed to publish the list of name of officers who are to be promoted from senior grade 2 to senior grade 1 of ACS officers before the end of each year and had failed to comply with Rule 12(1) of the Assam Civil Services Rules 98. And on such occasions, the respondent authorities had always considered the name of the eligible officers in the list for promotion of ACS officers from grade 2 to grade 1, though the list was published much after their retirement. Minutes of the selection board held on 8/9/2011 for the selection of officers for promotion from ACS senior grade 2 to senior grade 1 revealed that serial number 7, 15, and 17 of the select list retired from service on 31/3/2011, 39/2010, and 28/2/2011, respectively. And the name of the said incumbents appeared at serial number 6, 13, and 15 of the final selection. And these documents at page 35 and 37 clearly demonstrate that fact. And these facts have not been disputed. Now, my lord, a similar kind of a situation had arisen in Punjab. And if your lordship kindly takes up our affidavit in reply.
Who has filed
Statement. We have filed an affidavit in reply and we have annexed a Government of India OM, which will reflect the judicial pronouncement on a almost similar kind of a situation. Has my lord got it? The undersigned is directed to invite, it is a page 6. The undersigned is directed to invite attention.
Is it 25th of August?
25th of August 2010. The undersigned is directed to invite attention to Regulation 5(3) of IS Appointment by Promotion Regulation 1955, which reads as under. The committee shall not consider the cases of the members of the state civil service who have attained the age of 54 years on the first day of January of the year for which the select list is prepared. Against the above provision, Sri So-and-so, one of the state civil service officers of Punjab, had filed CWP number so-and-so before the Honorable High Court of Punjab and Haryana. The Honorable High Court, by their order dated 1st February 2010, interpreted the said provision as under. The sole question which emerges for determination of this court is whether the age of eligibility is required to be considered with reference to 1st January of the year for which the select list is prepared or any other date. A plain reading of the expression year in Regulation 2.1 shows that a year would mean the period commencing on January 1st and ending on December 31st of the same year. A further perusal of Regulation 5.3 would make it evident that the committee is debarred from considering the cases of such officers of the state civil service who have attained the age of 54 years. The regulation further says that the age of 54 years is required to be determined on January 1st of the year for which the select list is prepared. In the present case, 4 vacancies are of the year 2006 and 1 vacancy of earlier years became available in the year 2006 on account of non-joining of Sri so-and-so. It has been rightly contended that the emphasis in Regulation 5.3 is on the expression the year for which the select list is prepared, which would mean that meeting of the committee may be held in a subsequent year, but the eligibility of the officers insofar as his age is concerned would remain intact. It has to be judged with reference to the year for which the select list is prepared. We find substantive support to the aforesaid submission in unnumbered proviso to Regulation 5.1. According to the aforesaid proviso, if no meeting of the committee could be held during a year, then whenever the committee meets again, the select list has to be prepared separately for each year during which the committee could not meet as on 31st of each year. The aforesaid proviso is consistent with the definition of the expression year in Regulation 2.1, etc. Therefore, the vacancies for the year 2006, that is from 1/1/2006 to 31/12/2006, have to be determined as on 31st of that year. The select list, which has been erroneously styled as select list of 2007, in fact, is the select list for the year 2006. Therefore, the age of the petitioner has to be determined as on 1/1/2006. Accordingly, he would be eligible. But against this, the matter was taken to the Supreme Court, which is reflected in the next page. Next page itself of that same OMR. Against the above mentioned orders of the Honorable High Court,
Not
perhaps since it's a very old matter,
You
it
have
might have got torn up. I will make an extra copy.
no,
Madam.
no, it will
What-
make
Lordship, I'm sorry, I have to take the B file. In the B file, ironically, it is very clear enough.
no, there is no change.
Against the above mentioned orders of the Honorable High Court, this department had filed SLP number so-and-so before the Honorable Supreme Court, which has been dismissed. By order dated 31st May 2010. In view of the above, the order of the High Court has become absolute. Accordingly, the following decisions have been taken by the competent authority, and these, my lord, observations made by the High Court have been incorporated. The relevant will be the year for which this election is conducted, not the year in which this election is. Your Lordship is aware, my lord, there are a catena of judgments with regard to year of, it has to be done year-wise. I will just place one of them. I won't trouble the famous Banerjee's case, my lord. 97 9 SCC 287. Union of India versus NR Banerjee. And the relevant paragraph is
287, you said.
287. Relevant paragraph is para 12. Para 12 is a very long paragraph, my lord. The earlier decisions have been referred to. I won't trouble your lordship with the entire paragraph. I'll just read out the relevant portion, my lord. Your lordship will find the relevant portion at page 295. And this will be about line about 12 from bottom. There is a sentence starting on the left, however. However, in the light of the above principles and in the light of the clear rules extracted herein above, it is seen that the exercise of preparation of the panel is undertaken well in advance to fill up the clear vacancies or anticipated vacancies. The preparation and finalization of the yearly panel, unless duly certified by the appointing authority that no vacancy would arise or no suitable candidate was available, is a mandatory requirement. If the annual panel could not be prepared for any justifiable reason, year-wise panel of all eligible candidates within the zone of consideration for filling up the vacancies each year should be prepared and appointment made in accordance therewith. So this is the principle which has in fact been followed by Punjab and Haryana. And that has now, so far as the central government is concerned, there is a very specific OM. And similar are the provisions in our rules, Malad. If your lordship will kindly have the civil service rules. Manual.
Page?
If we are holding the same book, Malad, it starts at page 33. Assam Civil Service Rule. And the relevant provision is, Malad, sub-rule 1 of Rule 12 at page 39.
Page?
Page 39, Rule 12, sub-rule 1. Language is exactly as in the case of NR Banerjee's case.
Yes.
General procedure for promotion. Before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each cadre. Then, sub-rule 2. The appointing authority shall then furnish to the board the following documents and information with regard to as many officers in order of seniority as are eligible for promotion subject to a maximum of 4 times the number of actual vacancies. So a conjoint reading of these two rules will demonstrate that, taking the example of this particular case, the cases for promotion for 2011, actual vacancies and anticipated vacancies ought to have been considered before 31st of December 2010. And the exercise ought to have been undertaken in 2010 itself, so that promotions can be made of all eligible officers. Had that been the case, I would not have retired. And those 23 vacancies, there is no dispute that they were in existence. So had they undertaken this exercise, even assuming they could not do it for some reason by 31st of December 2010, even assuming they would have done it in the first part of the year by June, because I retired only in October, I would have still got the promotion. And it is this benefit that I'm asking for. At this stage, all I'll be entitled to is a little bit of financial benefit. But that is the case before your Lord. subject to what my learned friend, the only point taken by them is, so far as this 2010 who were given retrospective effect is concerned, those 3 persons, they want to say that there were some interim orders passed by the apex court, because of which selections could not be held. There, it was on account of assuming the delay was on account of some interim orders passed by the apex court. Here, again, the delay is not attributable to me. The delay is attributable to them. Whatever be the reason, be it some interim order passed by the apex court or be it any other reason for delay, that cannot be attributed to me. So this benefit will, similar benefit will certainly have to be given to me, whatever be the reason. Subject to what my learned friend says, that is, my prayer is your lordship will direct them to, if necessary, conduct a review DPC, consider my case and give me the benefit retrospectively so that I get the financial benefits.
Your consistency criteria that have pointed out that you got
Mal.
now it's not a question that you are above the criteria.
I will automatically. That is why my prayer is, my lord.
Your case address can be directly considered.
Exactly. That is why I am not saying.
Since you come into the zone of consideration of that particular year and which the vacancy arises, whether you fit into the criteria of merit, if it is held that you are eligible,
I will.
whatever proportional benefits, that is proportional benefits and for finance.
Had the criteria been seniority, I would have prayed for a mandamus for a direction from your lordship. Since it is merit with due regard to seniority, I cannot possibly make the prayer because they have to consider.
Hadarika, can be rest assured that we are not grant given except this condition. Financial benefits should only be in the fitment of the retirement for the period which he has not worked.
No, I am not even asking.
But if he was promoted and if he was deprived of not a manner which is recognized by law, then you have to give the pensionary benefit by putting in the proper fitment as if he had retired as senior grade 1. That is what may come. We like to have your
In fact, that is precisely my prayer.
First, Lordship, first the thing is that as far as your lordship query is concerned, your lordship, first let the even then, first even assuming that the DPC is there, then the DPC's result will come and then only the further decisions regarding when.
No, that's a different matter. But whether are you considering the fact that he's entitled to a consideration by DPC?
No. I'm because your lordship has asked that query. That's
you
why.
have to argue on that. The consequence part is not something for your lookout.
Lordship.
That will direct. That will protect the interest of both. But first, if you're opposing the petition, you have to make out a case that he was not even entitled for consideration. In spite of the fact that persons who are junior to him in the gradation, not junior, whose name had come below him in the gradation, was considered in for a year when the petitioner was still in service. If the exercise was done, then his case would have been done. But it was done in a period where by which time he was already out, so his case was not considered. His case is that had you made the assessment or exercise in the relevant time for the road, his case would have been considered. And if with the consideration he was given the proportion, then he gets the benefit. a different matter whether he gets promotion or not. That's a second question, a second exercise. But first, the primary thing, if you're opposing the decision, then you have to make out a case that
whether the date of his date, the relevant date will be from 1/1/2011 or 1/1/2012.
the vacancies of the year 2011.
Right.
23 numbers of it.
Right.
And he had retired on 31/10/2011.
So the issue is, Your Lordship, if it is our case, and that it will have to be all the vacancies etc. will come from 2012. My learned senior has talked about the NR Banerjee case, and it may be applicable for the Punjab and Haryana and the All India Services rules, Your Lordship.
Just let us read again 12. Rule 12.
Before the end of each year,
Before the end of each year,
the appointing authority shall make an assessment of likely number of vacancies to be filled up by promotion in the next year in each category. So,
and if the vacancies are in the year 2011, then by the end of 2010, an assessment has to be made. And vacancies assessed. And he makes exercise. Now he retired in October 2011. And if promotional exercise was done prior to that, he would have got a fair chance of being
considered. So here our argument would be that before the end of each year would denote end of 2011, because then who will retire, there may be someone who is deceased, there may be someone who is dead, or who is promoted, who has left the service, all these things. So 2011 will get a chance.
You have to read the entire sentence.
Before the end of each year, the appointing authority shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each category.
So the assessment has to be made on the previous year, the last part, regarding the vacancies which arise in the next. So 2011 vacancies, you cannot say that you are going to make an assessment end of 2000. When will you feel it?
Lordship, my humble submission is that I feel it can be
the
reading. The reading can be.
Those arguments don't make.
Lordship, no, my submission is that the reading of it can also be.
These submissions are these are this is the plain meaning. If you are assessing the vacancy of the same year at the end of the year, when did you make the promotion? You know the vacancy position before the starting of the year. That next year, this person are going to retire. Yes, anticipated vacancies, nobody can say. Somebody may take a voluntary retirement, some person may pass away. Those are the standard. But number of vacancies on the retirement, those are something which can be assessed. And when you assess, and before the end of the previous. So that
at the end of December, and then in the next
by
year,
December of 2010, you know who are retiring in 2011, 10 numbers. So in 2011, you do an exercise, fill up those. Now he retires in the year 2011 October, and these vacancies are of the year 2011 20 number.
So it boils down to the point of when it will be considered, Your Lordship. And my submission, Your Lordship, has already said to be a stale submission, Your Lordship. So I would not like to.
Not be a correct interpretation.
But
if you have anything else to say,
Lordship, this para 6 and 7 is our crux of in our affidavit is the crux of our submission. Sir.
paragraph
6 and 7 of our affidavit. It comes down to the same thing, Your Lordship. It was the selection board meeting was held on 27/3/12, and by the time he has retired, so he was not considered. That is our in para 6, Your Lordship. In para 7, we have described the situation where the Supreme Court case has come in and where the seniority list has been
have you
recasted.
stated anything regarding what the general practice of?
No.
Is it the only case where you have left out persons who have retired?
No, to my knowledge, there's at least one or two other cases which are they're based on this issue only, that what is the date of prayer. And
now he has cited precedents. you said that there are some
cases, pending cases. Regarding this issue, I remember one or two cases where the same this board meeting was also there, Your Lordship. Unfortunately, I cannot remember the name of the
but
case.
here you cannot exclude the fault of the why you had not done it.
But we basically tried to explain why in the para 7, why the Supreme Court case is there and all this, and how 2, 7, 8, 9, and 10 selection board, the year meeting, how it was held, why it was held. We have tried
You
to
are still
explain it.
required to follow the criteria of merit with due regard to
Merit
merit
with-
with due regard to
Okay.
whether he comes to the merit doesn't matter which numbers of but if you go by the gradation list, it appears that you would have a fair chance of being isn't it? Because number of vacancies 4 times you have to consider.
So 92, then
So he fits the zone of concern.
Ah.
Now whether it actually fits the criteria of promotion, that's a different issue.
for that the DPC will be there. Short.
What is your general practice? This kind of why are you have you showed any reason why you are not put whole
For this year or normal, the general practice, Your Lordship is
no, that case.
because of this, Lordship, first, if we look at on the last occasion, I remember looking at the records of the other case, there the why, first these 3 years, they had all this selection committee meeting and all these things were done. Thereafter, the next exercise had to be done. By the time, so it took some time, why sometimes the chief secretary was not available, sometimes it took some time to set up the body, and then in 2012, this board was held, and then on that case also, on all of the cases, Your Lordship, the person is retired, and that's why they were not considered, Your Lordship. That is as far as these things are concerned. As far as the general practice being followed now in normal course, Your Lordship, that our understanding is that it is done in the next year, Your Lordship, which Your Lordship has not found favor.
No, that's not the plain. Second is the plain mean. For the end of which year? Let us hypothetical whole this year, 2020. For the end of 2023, the appointing authority shall make an assessment of the likely numbers of vacancies to fill up a position in the next year. That is 24 vacancies in the year 2024. You have to make the assessment in the end of 2020. There is no other meaning. Just one.
Our understanding was, the understanding was that 23 let it end. Will
No,
understand.
if that is your understanding, to us on the previous occasion that you had proceeded on this, previous have to be done, assessment have to be done at the end of the previous year.
I'm sorry to interrupt, my lord. That is not the interpretation, because that is what they are saying in the affidavit also. If your lordship kindly sees their affidavit for a moment. Exactly what has fallen from your lordship. Indirectly, they are saying in the context of the 2008, 9, and 10 vacancies. Page 3 of the affidavit. Paragraph 7, there are several subparagraphs. It is the 4th subparagraph. my lord. The first sentence itself makes the position very clear. That since the selection board meeting for filling up the vacancies for the year 2008, 9, and 10 could not be held on time, in view of the pendency of so and so, the selection board decided to give retrospective promotion to it. So their understanding also is because there cannot be any other interpretation to that rule.
These vacancies are of the year 2011, no dispute. 2000 vacancies we have filled up in 11. Those cannot buy vacancies. And these vacancies, the assessment have to be done when by the end of 2010, we had done. You knew that vacancy number of year arise in 2011. So you do a promotional exercise in 11 so that The moment somebody does
The list is already there. so
that
you
and
put them from there.
somebody will promote it. Now here you do the promotion exercise when 2012 March. By the time get it's not your case that you had done right even in December. In that we might have said something. Not doing that here itself. When did he retire? He retired in October 2011. Could have done November also, then perhaps also could have said yes. This is that. He did not do that. He had done 1 year. At least that 11 had passed.
So then he gets the benefit of the entire year.
And simultaneously, my lord, 12.2 says all eligible officers. So which automatically brings me in.
First step has already taken this up for disposal. That's why otherwise I would have tried to find some, if possible, some other case or something. Your Lordship.
These are all matters. These are
Lordship,
meant
that's
for,
why I already, Your Lordship, has
for
said
taking up for disposal. We have heard this on place of this. We have passed judgment that we have gone for it. Somebody know, but we're not here. Close. Not place of but to the thinking aloud, we'll ask for direct for consideration. And if it's in criteria of motion that is married, and if anybody is below him, segregation has happened and has more marks. Any of the 12 men. What's your age now?
Around 72, 73.
Okay, so call the next. You tomorrow. You even if they have another roster.
Deeply obliged.
May it please your Lordship, my lord, this kindly see the earlier order dated 11/5/2018 and 5/2/2018.
Yes.
My lord, in this order, my lord, I am the my lord SC candidate. My name was shown in the my lord list as a general category. And if the my lord, I am the SC candidate, my mark is above than the my lord, respondent number 3.
Who's for a private respondent?
Number 6.
Lordship, in this case, Lordship, in
Private is N.T. Sharma. N.T. Sharma.
order dated 9/3/18, Lordship, record is required, Lordship. This honorable court is directed to produce the record, Lordship, for the selection process, Lordship.
Just
In this case, the core issue is whether the petitioner is a SP candidate or not. That is why the record is required, Lordship. So that record, Lordship may kindly pass for the matter, Lordship, so that I can
2012
produce the
matter, we are
record.
not going to pass over for record. 12 matters are for you are not being able to produce the records.
Because the case is also not come up in the least lordship after the last order lordship. the
Doesn't
18th.
matter, 2012 matter, is it reasonable to adjourn a matter of 2012? That was it. We'll hear him and
My lord. My lord, kindly see my lord page in the repetition page
what is
80.
your grievance? So, please tell-
Grievance, my lord, I am the scheduled caste. My lord, my name was as a selection list as the general candidate. A general mark, my lord.
Just a minute. You belong to the scheduled customer.
My lord, I also just annex the certificate.
Is it in dispute? Is your community, is your caste in dispute?
No, my lord, notice.
Then what is it?
My lord, this would, my lord, this selection list, my lord, kindly see
For selection for what?
selection for ward girls, my lord.
What card?
Ward girls.
When was it held? Tell us the facts.
My lord, fact, my lord, kindly see the page 18, my lord.
Tell us. We will go to page 8. What has happened? Start. There was an advertisement.
Read.
What?
Advertisement, my lord, kindly see my additional affidavit. Additional affidavit, my lord. Page number, my lord. No, 6, my lord. Additional affidavit.
To edit facts, we go to the affidavit.
My lord, my
What has happened? Haven't you prepared a list of dates?
my
What
lord,
has
as per advertisement, my lord.
Tell us the date of the advertisement. What has happened?
As per advertisement, my lord.
Date of advertisement, year of advertisement.
Advertisement, my lord, 21/10/2021.
21.
11, 2011, my lord. Sorry.
Advertisement for what? Appointment of what, sir?
My inviting for the standard form of the publish of the Assam Gazette, so and so, for the post of ward girl, 2 post STP, 3 post OBC, MOBC, and 2 post SC. 2 post SC.
Total number of posts. Total post. SC, how much?
SC, my lord, only 2 posts.
Two vacancies. Two posts the first.
SC, my lord.
Thereafter, what?
Thereafter, my lord, I
You appear.
appear in the my lord interview and written, and thereafter, my lord, I file 2 candidate was SC, my lord, selected.
Yeah.
Then I filed before this honorable court for challenging the my lord, challenging the impugned list, my lord.
Okay.
List, my lord, those who are selected, my lord, 2 posts, my lord. The one, my lord, name is Bina Das, and another
Where is the
select list, my lord, repetition page, my lord, annexer 9 page, my lord, 22. 22. Annexer 9. My lord, SC candidate 204048 roll number.
Yes.
His name is Mosumi Roy, and 2049 is Bina Das.
Yes.
My lord, this Bina Das got mark 116 total mark as a SC. And my lord, the Mosumi Roy, he got the mark, total mark 102.5.
Bina Das, how much?
Bina Das mark 116. Total mark 116. Mosumi 102.5.
How much did you get?
I am get, my lord, 1.5.
1.5. You are more than Muslim.
More than Mosumi. Thereafter, I filed, my lord, this impleading as their respondent number 6 as Mosumi. And his, my lord, learned friend also appeared. This is the, my lord, the notice impugned, annexer 9, page 22. Thereafter, my lord, I filed the additional affidavit. Kindly see my additional affidavit. Page number 6, my lord. This is the advertisement, my lord. Additional affidavit, page 6.
Where do you get the, from where do you get the mark?
My lord, mark, my lord, kindly see page 8, my lord, Annexure C in my additional affidavit.
Eight?
8, my
Now
lord.
first one to
My lord, the serial number 1.
show page 6, why?
This
This
is
is
the
the
mark, my lord. This is the mark,
advertisement.
Ah.
This is the advertisement.
my lord.
2110.
My lord, Annexure page 6 advertisement.
Yes.
Annexure 7 is the, my lord, selected Bina Das and Mousumi Roy. Page 7, Bina Das mark 116 and Mousumi Roy mark 103.
Yes.
Thereafter, my lord,
Mousumi is 103.
My
Is
lord.
that 102.5?
My lord, kindly see page 8, my lord. 8 serial number 1 Mousumi Roy. Serial number 1 Mousumi Roy total mark, my lord, 102.5. Last.
Yes.
Thereafter, my lord,
Where is your mark?
my lord. Thereafter, my lord, kindly see page number, my lord, 15. 15 is the Bina Das. Serial number 45. Page 15.
Yes, not.
45. Bina Das got mark 116.
Yes.
This is the, my lord, highest mark. Thereafter, my lord, page 16. Serial number 48. 48 my lord, my mark, my serial number 48.
But
page
you have been held to be general. You have been held to be general.
general. In place of SC, my general category, my for the mark 111.5.
Yes.
That is my grievance, my lord. When I admission, my lord, I form fill up on the SC as a candidate is about all documents submitted before the authority. When the select list was published, my lord, and came to after filing this case, I came to know that, my lord, my candidate, my lord, as general instead of, my lord, SC.
Let us see your application. Your application.
My lord, application, my lord, is already on record, my lord.
Where you stated that you are SC candidate? Where are you stated? Regarding your page.
This is why, my lord, this record already called for, but my application already there. My grievance, my lord, instead of general, I am the SC candidate. Already SC certificate also annexed, my lord. This petition, my lord. And my lord, if I am the SC candidate, my lord, my mark already recorded in the general instead of SC. If my mark is, my lord, SC, as the SC, I am the highest mark from the restaurant number 6. And as per the earlier order dated, my lord,
Why have you regarded her as unreserved candidate?
That is, we have filed an affidavit, lordship.
Yes.
We have stated in paragraph 4, lordship, the written test for word girl appeared in the viva voce. However, she could not come out successful in the final selection, which was made on total marks obtained by the candidate in written and viva voce test. Then, lordship, paragraph 5, the contention which was the petitioner, Mousumi Roy and Bina Das, did not appear in the oral interview, but they will appear in the oral interview.
No, that's
Duly
not the
appeared,
point
lordship.
we are considering. We are considering a simple point. Petitioner is stating that she belongs to the scheduled caste category.
Scheduled caste
And-
category, that is not, we have to prove it whether she has applied as a candidate for SC candidate or
Exactly.
as a general candidate. That is why the record is required, Lord.
If you are not able to produce the records till now,
Now we have already today morning also I have short date may be given lordship. I'll produce the record. It's a selection and selection of 2012 lordship. On Monday lordship.
Earlier order, my lord, 11/5/18 and 5/2/18. Already, my lord, observation is given, my lord, by this honorable court, my lord.
Did you clear your test?
Yes.
You're cleared?
Yes.
What is your roll number?
Roll number, my lord, kindly see my roll number. Page number, my lord.
205011.
My roll number, kindly see page 8, annexer 8, page 21.
205011.
21, my
0501.
my roll number 205011. As per my lord, annexer 8, page 21. In the ward government. Annexer 8, page 21. My lord, is last right side, my lord. 205011. And my lord, is polling letter, my lord. Polling letter.
Just keep calling that the coordinator is 20. 20, isn't it?
Polling letter also, my lord.
Who's it? Page 20.
Page 20 annexer 7.
My lord.
There is no reference to
No lordship, it's not there.
And accordingly, I appear written test, viva test, and complete it, my lord. Process, my lord.
Madam, you have got call letters of other candidates. How, while doing the call letters, do you indicate the category of the candidate?
That is the
My lord.
record will say lordship. I do.
My lord, if I am the general, my calling letter not issued. I am the schedule card. Thereafter, is the calling letter.
No, page 20 your call letter.
My lord.
There is not
Annexer 7.
mentioned.
My lord.
That has not indicated that you are card.
Yes.
We are asking Madam whether our candidate belongs to the certificate category. Is there is some indication of call letter?
Record will say lordship.
And we also wanted to cross check in the list of persons who were shortlisted for the interview. Those it contains your name, but those are not in the category wise is not given. Roll numbers including all categories at page 21. 21 has got your roll number, isn't it? 205011.
My lord.
And it has indicated that it includes all categories. So from this cannot.
If, my lord, this is supposed to be, my lord, is wrongly, my lord, written this by the authority, my lord.
But Madam, she is a scheduled caste candidate. She has
Certificate also, my
why
lord.
she will not avail the benefit?
My lord, I am my certificate also annexed.
What have you stated regarding her? Regarding her certificate, I think you have stated her.
My certificate page 6, my lord, annexer 6, page 18. As per my lord, my petitioner instruction, I filed this case.
How you replied to paragraph 3, madam? Paragraph 3. Comment of sir. If this is the kind of reply you are giving, then how do you defend your case? Come to page 2 of your paragraph 3.
Paragraph 3,
With regard to the
we have
statements
not
made in
mentioned
paragraph 1 to
anything.
5, no comment.
No comment.
You are not even refuting or disputing that he belongs to the custody.
Lordship may fix it at 2 o'clock. I'll go through it, but 2 o'clock.
So it may be a mistake. If it's a mistake, you have to rectify. You cannot deny somebody's entitlement. And if you are disputing that her caste, then matter would be different. There is not even a single line.
Line, yes, Lord.
Rather,
why.
he is categorical asserts that belongs to the custody. There is no reply. There is no
Yes.
comment. You have not dealt with the main track, which is has to be adjudicated. He says that says that he belongs to the caste category.
Lord.
And he applied to the scheduled caste category, given a certificate.
But in our
Then
affidavit,
there are
not
there
mentioned
are
anywhere.
two vacancies of scheduled caste in which one of the candidates has secured less, and he has been treated general. Now to say that he had applied as general all around, that matter is different.
Right.
But her assertion you have not even denied. Okay, we'll give one chance.
Sure.
Tomorrow you produce the record.
I'll try my best.
Or get it. When it comes to also, but keep order. When standing on as an everywhere. It will involve is with regard to the assertion made by the petitioner that belongs to scheduled caste committee and had participated in a recruitment process created by President 2110 for one as word for the grievance is precise. The grievance precise that one can very best mark have been given the benefit of the effort and the petitioner who had got more marks has been denied the same by terming her to be a general candidate. I must for us that any that that now put it done, put it the record that consider that it okay, that such best such get the power a last and direct for on the column of the on first of the on on the 20th of August Monday.
Habla.
and try to look at who is for the try to look at who is for the responsibility. Andy Sharma, PK Sharma, try to inform them.
Mal.
At number one, first if I call up Mr. DP Solier Jr., he said that the file has been taken, the brief has been taken from them.
Non-accessible petitioners are called, whereas case is represented by he has a state council. Matter was called when this matter was called, there was no representation at the court. The United Government Council was requested was requested to inform the United Council was the other because the government however has take back by the from from council appeal for them. Consider the above and the above, put
In item 5, Lordship, we have been directed to take the instructions regarding the inquiry conducted, Lordship. The inquiry has been conducted, Lordship, and thereafter it was placed before the appropriate authority. And it's still awaiting about their action on the basis of that report, Lordship. So may I pray, Lordship, let me,
what the issue
regarding some,
allegation.
yes, recruitment of 17 numbers of grade 3 posts. Some certain allegations are there accordingly.
Recruitment process. Allegations of anomalies in the recruitment process.
Seems to be.
No, that is the allegation.
Lordship.
Thereafter, an inquiry was held.
Inquiry was
Against
conducted,
the-
inquiry
against the
report was
petitioner.
submitted.
Against the petition.
No, Lordship. Petitioners has alleged that there are certain anomalies in the recruitment process of that. Fill up that.
Petitioners were candidates.
Lord.
And they have alleged anomalies in the
Lord.
recruitment process.
Lord.
And you had initiated an inquiry
Yes.
in the allegation.
On the direction issued by the principal secretary.
So it was
Let us get the whole instruction.
your G Swami or MSC Swami of each submits that
May I read, Lordship?
that the inquiry which was initiated to look into the allegation of anomaly in the recruitment process is yet to be finalized.
Okay.
And in this regard, he has also referred to the earlier order of this court dated 5/8, wherein certain observations have been where Mr. Sharma what is done.
Lordship, let it be multiple, 3 or 4 weeks.
Further 3 weeks time, further 4 weeks time to obtain the latest list of
Lordship, date may be fixed. Lordship, a date may be fixed.
list of
20 of September.
20, let it be last week of September.
20 to
20.
report.
Obliged.
Much over.
My, may please, Your Lordship. My lord, this case is fixed.
An affidavit has been filed in the matter on behalf of the judicial department. Sir. Lordship will find the affidavit at page 43. Page 43.
Maybe this will be-
Who is the respondent?
Purubi Kolita. Sir. Page 43. Has not been put. Look, for paragraph 8 and para 13 is the stand.
Paragraph.
Paragraph 8. So in fact, I'll take your lordship to paragraph 8. Sir. The particular office memorandum which has been referred in paragraph 8, this office memorandum is available in the writ petition that the lordship will find at page 27 of the writ petition. There are two office memorandums. One is 30th of March 22, page 22, annexure 2.
Which one dated? Dated of?
30th of March 2012.
Yes.
At page 22, annexure 2. This is the office memorandum by which now the stand has been taken by the finance department as well as the judicial department that the post of sweeper, if kindly come to page 23. It starts, the office memorandum of the
Yes.
finance department, it starts.
Yes.
Lordship may kindly come to second page, serial number 8. At 20. Eight, sweeping and cleaning services are to be outsourced, and the post of sweeper shall not be filled up in any department on any ground, including compassionate ground, except in government hospitals, as per the stand of the government already submitted before the honorable court, and a judgment issued thereon in WPC number so and so. Based on these stand, contravention thereof will entail personal liability of the concerned appointing authority. By this, sweeper post has been made outsourced. Then subsequent page 27, another office memorandum came along at page 27, annexure 4. This office memorandum of 2012 has been partially relaxed. This says, in partial relaxation,
OM dated?
OM dated 6/6/2015.
15.
15, yeah, 15.
Yes.
Page 27. This says, in partial relaxation of clause 3 and clause 7 of the office memorandum number so and so dated 30/3/2012 issued by the finance department, it has been decided to exempt the Honorable High Court, Honorable Guwahati High Court and its subordinate judiciary from the purview of prior approval of the administrative department, that is judicial department and finance SIU department, for filling up the sanctioned vacant post of grade 1, 2, 3 and 4 as the case may be, which are necessary to be filled up in the public interest. The other terms and conditions will remain same as per office memorandum number so and so dated 30/3/2012. So, petitioner has contended that in respect of subordinate judiciary, by this office memorandum, relaxation has been given. The relaxation is given only in respect of clause 3 and clause 7, not in respect of clause 8. Now, kindly come to our affidavit. Our affidavit at,
Yes.
at page 46, paragraph 8. That with regard to the statements made in paragraph 7 of the writ petition, it is a matter of record. Nothing is admitted by the answering respondent beyond the relevant records. Further, the deponent respectfully states that the government of Assam Finance Department by office memorandum number so and so dated 6/6/2015 partially modified the clause 3 and clause 7 of the earlier office memorandum number so and so dated 30/3/2012, relaxing the provision of prior approval to the Honorable High Court and from the Finance Department and Administrative Department. The said office memorandum dated 3/6/2015 clearly stated that the Honorable Guwahati High Court and its subordinate judiciaries are exempted from the mandates of prior approval from the Administrative Department, that is the Judicial Department and the Finance SIU Department, for filling up the vacant post of grade 1, 2, 3, and 4 posts, but the state notification did not provide and relaxation exemption in regard to the post of sweeper. As such, considering the exemption provision of the prior approval from the Administrative Department, that is the Judicial Department and the Finance SIU Department, in regard to appointment of sweeper cannot be considered in view of the office memorandum dated 6/6/2015. So we said that the sweeper has been made outsourced by the 2012 and it remains as such. So there cannot be regular appointment in the post of and paragraph 13. That with regard to the statements made in paragraph 2 and so, the deponent respectfully states that the Government of Assam Judicial Department created 158 number of posts for the establishment of the district and session judge court and chief judicial magistrate court in 3 newly created districts of Assam, namely Udalguri, Chirang, and Baksa in the year 2007, created by office letter number so and so dated 31/3/2007. But thereafter, the Finance Department by office memorandum number so and so dated 30/3/2012 directed that sweeping and cleaning services are to be outsourced and such posts shall not be filled up in any department on any ground, including compassionate appointment, except in government hospitals. The office memorandum dated 6/6/2015 had given relaxation to the Honorable Guwahati High Court and its subordinate judiciaries from the mandate of the prior approval from the Administrative Department and Finance SIU Department in respect of grade 1, 2, 3, and 4 posts, but the state notification did not provide the and relaxation exemption in regard to the post of sweeper. In view of the office memorandum, in view of the restrictions imposed by the memorandum dated 30/3/2012, the claim of the petitioner cannot be considered as valid. This is the specific stand of the department. Now, if lordship really comes to the writ petition in the prayer made by the writ petitioner, he has prayed for release of his pay and monthly salary with effect from the date of joining on 18/7/2016. Prayer lordship will find at page 17 in the writ petition. Lordship will find
Yes.
his prayer in the writ petition is for paragraph page 17, is to release and pay the monthly salaries and as entitled by the petitioner with effect from the date of joining, that is 18/7/2016, in his service in the post of sweeper in the establishment of district and session judge Chirang, Adolgaon. That is his prayer. He was appointed pursuant to advertisement at page 28, annexure 5. It was issued on 12th of August 2015. This was the letter to the Director of Information and Public Relations. Page 28, the District and Session Judge Chirang Kajolgaon, he has requested the Director of Information and Public Relations for publication of the advertisement.
At page 8.
At 28, page 28. The post is mentioned at page 29. On 12th of August 2015, annexure 5. Thereafter, the petitioner was call for the Viva at page 34, Malad. At page 34, Annexure 7.
Advertisement,
Advertisement, Lordship,
page 29.
page 20. Yes, Malad, this is the enclosed advertisement. Lordship will find
Sweeper one.
Super one. Thereafter, Malad. Page 34, he was called for the Viva on 2nd of November 2015. Then next page, Malad, he was selected.
What is it?
Look. 2/11/2015. Then next page, page 35, on the basis of resolution dated 22/6/2016, adopted by the selection board, the following candidates are selected for the post of torpedoer, sweeper, and driver in the establishment of district and session judge Chirang Pachal. Petitioner at serial at 2, Malad.
Yes.
On 24/6/2016, and thereafter he has been appointed on 15/7/2016. And page 37, he has joined in his service. Malad, the initiation of the advertisement and the entire selection process is after the notification of the office memorandum of 2015, 2012 and 2015. So, Malad, therefore, the sweeper post would not have been filled up regularly. It should have been filled up on outsource.
Yes.
Malad, the first salary, he joined on, Malad, after his joining, for the first month salary that has been processed, and it was taken up, and ultimately the judicial department, they have written to the district and session judge at page 42, annexure 11. This is the, with reference to the letter on the subject cited above, I am directed to inform you that the finance SI department was moved for release of first salary to the new appointee as proposed by letter on the reference, but instead of release of first salary, the finance SIO department returned the file with endorsement as reproduced below. The department is requested to clarify as to why the Suresh Rajbhor was appointed as sweeper, as the post of sweeper is outsourced by finance department's office memorandum by number so and so dated 30/3/2012. On that ground, the first salary was not paid.
Now, how do you deal with this?
Look, he has to be treated as an outsource since he has been appointed and he is working, and the fixed salary for the outsource that has to be processed. The proposal will come accordingly. Department will consider.
Do that at least.
No, the authority, appointing authority has to do that. He has to be treated as an outsource.
See, there are two issues.
No,
We have considered your submission.
Look.
That OM does not exclude the within the subsequent OM, which has clarified certain aspects of the initial OM of 2016, does not even touch clause 8. Touches only clause 3 and 7. which has got nothing to do with outsourcing job of a sweeper. Now, in spite of that, there was a selection process. His interaction in the service is not something that can be termed as illegal.
No, it is irregular.
It is irregular at best, because there was a policy to do the work of sweeping by outsourcing. And in spite of there being such a policy, the London district judge has gone ahead with a selection process, where one government has been selected appointed. It is also not your case that subsequent spite of this of that sweeping activity that has been outsourced, the particular court at Chirag has got a sweeper through outsourcing. It's not your.
No.
He is still doing the.
Yes, yes.
Now, the question that he has claimed for salary from the date where he has come into the service, that is 87,016. Now, he cannot utilize the service of a contractor
Yes.
without salary.
Absolutely.
It can be salary, it can be fixed pay. If you say that it has to be outsourced, and at least the salary he will be employed. That must get and get not only get
Nothing, no, only he has stated the fact that yes, was appointed, he has not been set. Otherwise, my lord, that has to be taken because an irregularity has happened. Now the salary, fixed salary, he is entitled. He will,
how much is the fixed salary?
possibly it is in my office. I have a person of this same nature. He is getting 9,000 rupees.
And what was the scale which was at
No, scale is not outsourced.
Yes,
for
madam.
how much
employee.
was the as per your terms of appointment?
Advertisement, what will
As
find?
per-
Page 29. my lord.
Yes, yes.
Scale he is mentioned. Like Chokidar and peon, it is mentioned.
Your lordship is 29, page 29. It is from rupees 4,560, along with 15,000 plus 1,500 as gateway. This is at page 29.
Page 29, similar as peon, Chokidar, sweeper, it is possibly that OM has been overlooked.
And this selection process, though it was initiated by the Senate, of course, he is the person who has to initiate. It was not done by his own. There was a proper advertisement through the DIPR.
This proper in fact, my lord, there is a ambiguity, your lordship kindly see. People is a great for that. As per our high court rules. My lord. As per high court rules.
No,
So, your lordship kindly
it's
see.
about the this one fact, this poem of 2000 not the subject matter of text.
My lord.
That policy of giving the job of work as an outsourced job.
No.
That is not that policy is not subject matter of salary.
My lord.
Now that was an existing policy.
2012.
2012.
That is why I am submitting, my lord. Your lordship kindly see page 32, my lord. Page 32. Page 32. So that means and that 2012 there is no post of sweeper in any department in Assam. No post. It could not be included in the my lord list of my lord employees, my lord. Your lordship kindly see page 32, my lord. That was the letter issued by the Deputy Secretary of the Government of Assam Judicial Department to the Accountant General, my lord. Your lordship kindly see, this is dated dispute 4th November 2015. I am directed to convey the sanction of the Government of Assam to the permanent retention of the following 158 numbers of posts which were originally created by the government letter reference for the establishment of the district and session judge court in
Chief Judicial Magistrate in the 3 newly created district subdivision, namely Udalguri, Sirang, Baska, with effect from 1/3/2015. And the usual scale pay allowances admissible under the rule. The district and session judge establishment in 3 court, Udalguri, Sirang, and Baska. These are the posts, my lord. Your lordship kindly see. Chief Judicial Magistrate establishment in Udalguri, Sirang, and Baska. And serial number 14 is sweeper.
15.
No,
no,
14 is sweeper, 15 is diver.
Page?
Page 33, my lord. My lord.
No, he is not citizen.
My lord, my lord, it is also, yes, my lord, it is in respect of district judge, my lord, it is serial number 15, my lord, yes. Now, my lord, your lordship kindly say last portion. The expenditure will be deductible and the head of the account of so and the sanction is issued in terms of the office memorandum issued by the finance department by so and so. So that means the sanction is issued in terms of the office memorandum finance department. So that means finance department that 2015, my lord, finance department knows it very well. That was just published in 2015, my lord. His sanction is issued in terms of the office memorandum issued by the finance department, that is 2012, that is 2020. So
both this finance department OM are subsequent to 6/15, Mr. Nag. No, it doesn't matter. It refers to OM by the finance department. One is of July 15, one is of September 15. And your subsequent OM we not to accept, we'll go by the plain meaning that there was no tampering with the clause 8, 3 and 7 was modified, and so 33/2012 still existed. In spite of that, there are 2 official of which has given go ahead. By whom? Not by the district judge, by you. The government has given permanent retention 108 posts, including the post of 3 posts of sweeper. No, what is the intimation? What was the content of the intimation? Regarding permanent retention.
And in fact, in my affidavit, my lord, the letter which was sent by us, because there we clarified our position, annexure 1, page 58 of my affidavit.
And special mention has been made with regard to the 3 districts, including the district of Sirang. Yes. So you have been for permanent retention, not retention. You have conveyed the retention. The governor of Assam has conveyed has sanctioned the permanent retention. Even if there is a policy decision, these 3 districts are required to treat separately unless to modify. Otherwise, we would have accepted. There was no difficulty in accepting a submission. There is a general policy for outsourced job of first. But this notification is by your department. And this cannot say that something coming up 2007. The document of communication of November 15 saying that permanent retention has been done for certain posts, which includes 3 posts of sweeper in the establishment of district such as in Sirang. Unless clarified by a after notice, that you did not know whether after permanent petition is in sanction, whether you can now say that no.
In fact, my lord, in annex 1 of my affidavit, my lord, we have clarified the position, our position, that I have clearly written that my letter, annex 1, page 58, your lordship kindly see.
Just a Fifteen, you have written permanent petition. Those posts have to be written unless you say that the petition super is concerned is reserve not be a permanent post of the cadre, be out.
So we clarify our 10 in 2000,
Page
page 58, my lord, annex
58.
1, page 58, my lord. My affidavit only, affidavit of position filed by the respondent number 3 and 4, my lord. Name, my lord. Shri Kalyanjit Soikia. Page 52, maybe my lord 50. My lord, pagination, my lord, maybe
51.
51.
51.
Annex 1, my lord.
1 second. On here. No, it starts at page 1. AI. Right.
No.
R3 and 4.
My lord.
That's all.
No, actually, my lord, that the affidavit filed by the judicial department was not have on me. That's why probably pagination, my lord.
Doesn't matter. You are referring to which annexure?
Annexure 1. Probably page 50.
16.7.
Yes, my lord, 16.7.
16.3.
Yes, my lord. From district and session judge Chirang to the deputy LR, deputy secretary of the government of Assam, judicial department, disposition. Clarification regarding appointment of Sri Suresh Rajbor for the post of sweeper in the establishment district and session judge Chirang. Reference, your letter dated 25th January 2017. With reference to the above, I have the honor to state that district and session judicial court Chirang Kolajangaon was inaugurated on 13 to 2015 and based on the sanctioned strength of the government Assam by data dated 31st March 2007. Then district and session judge Chirang had invited the application for post of sweeper by his office advertisement number dated so which is published in widely circulated in English Daily Assam Tribune dated so. According to this office had conducted the oral interview on 9/12/2015 for the post of sweeper and based on the interview mark, today's dashboard was selected and thus the thanks of the resolution the selection board meeting dated and subsequently he was appointed to the post of sweeper by the office number dated and so. It may be pointed out that the sanction
So we'll continue at 2 o'clock.
my lord.
That is just 10. Otherwise.
Yes, no, my lord. Last line, my lord.
So we will continue.
Last line, my last para is important. Last para of the my lord. Next page, my last para. It is what mentioned here that note that the permanent retention of the post of sweeper in the district and session judge established and Chirang was
We have read that.
Yeah.
4:11:15. We have read.
yes 4/11.
Okay. The principal ground of challenge is non-finalized to the petition before the promotion to the post of headmaster. So the importance of petition cannot be seen. The criteria for promotion is innate come again. case laws which have been cited on behalf of the petitioners mainly for select this for the purpose of effort. However, there is a considerable difference between selection and accusation, whereas the person empaneled in the select may have a cause of action to be espoused, and persons to him have been given appointment or selection was taken by fraud. The instant case declaration provides the name of the card, and such candidates are considered for promotion by applying criteria which in the instant case near become court also cannot be oblivious to the fact that the question of care is of care and promotions were made based on such version year 2007. And in the meantime, almost years have passed, though there was no delay of the petition approach. In the meantime, there has been many developments such as many of the students involved have been amalgamated with high schools, and the incumbents were promoted to the post of headmaster. In the LPU school were given the appointment of assistant in the amalgamated school as per the office of students. It is also not good that many of the private respondents have retired from service and few of them also expired. It also transferred the issue of vis-a-vis the private respondents the disputed one, and in fact there are categorical statements that students in the state. In view of the aforesaid discussion, interfering with the appointment orders after considerable length of time, more than years, which was done on the basis of this may not be in public. At the same time, the rights of any of the persons cannot be allowed to be. Therefore, without interfering with the appointments of the private, this court of the opinion of the serve the well. The petitioners in these two cases are directly considered for their present next term of headmaster head. And if such promotions are to be made in any amalgam to the post of assistant headmaster, such amalgam, according to the petitioners, may submit necessary application for the director of public secondary education documents to that they are senior to any of the incumbents who were promoted pursuant to education year 2016. And in that event, after verification, such of the petitioners are considered for the higher as mentioned above by applying respect criteria of senior and thereafter can respond to the offered. The effort to exercise completed and within a period of 3 months, date of furnishing certified copy. So becomes further.
Please, your Lord, this matter may be taken up after some. Mr. Dinath is only in division bench 2, Lord. He has a prefix matter in division bench.
We have already had this matter.
If it is possible, Lord, can it be taken up after some time?
There is nothing for him to he has extensively argued. We will after some time.
In the meantime, I have also procured that those two memorandum difference of was given by Lord is that legal department.
Let him come then.
Lord, public.
Ask Mr. Mohammed.
Public. This is a case for selection and appointment to the post of administrative officer in the district of Bakshan. Lordship will find
Not yet admitted. Not yet been admitted.
admitted. Already pleadings are complete, everything is ready. Lordship, it is fixed for disposal, considering the fact that the petitioner is going to return on December.
On the last occasion, the record was also called for. I have the record with me.
Lordship will find the advertisement at page 24 of
Matter has not been admitted. We'll have for admission here. No problem. You're ready? Are you ready for the
Lordship. Biddings are
Okay.
completed.
If Dr. takes up bills, I don't have any. Next date,
22 Matt, your client is retiring in December.
December.
any other detail?
Right? So we're going to deliver the judgment.
Lordship. But my case is on 2 points. Lordship. The post of administrative officer is a new selection and appointment post. As per Assam district
Post of AO.
administrative officer
AO.
in the district of Baksha, in the district establishment of the DC Baska. Baksa, Moshalpur.
There was an
Advertisement. Advertisement, Lordship will find at page 24. Lordship. Dated 17 December 2020.
2022.
2020. As per rule, as per advertisement, a person must have 15 years of service in Deputy Commissioner
Experience.
15 years of service.
That is the experience.
Lordship. Any Deputy Commissioner establishment in Assam, that is the eligibility condition.
Established.
Lordship.
It's an eligibility criteria.
Eligibility criteria. And selection will be made on the basis of the ACR of 5 years ACR, as well as the other qualification and the achievement by the person.
There is no test such. There is no selected test as such.
No. It is a direct recruitment post. It is a direct recruitment post. Any employee of any other deputy commissioner of page 24.
Not a professional.
No. It is selection. Page 24. Applications are invited from eligible candidates in standard form for filling up the vacant post of administrative officer in the amalgamated establishment of the Deputy Commissioner Bakta in the scale of Iman plus other allowances admissible as per provision of Assam Service ROP Rules 2017 and Amendment Rules Iman. The candidate must have served at least 15 years of service in a Deputy Commissioner establishment in Assam and must fulfill established the condition and have experience as per Assam Municipal District Establishment Service Amendment Rules 2009. So any office they have to work in the Deputy Commissioner establishment.
Yes.
Lordship, altogether 4 persons has applied for the post. Lordship will find
including you.
Including me. Page 27.
You applied along with 3.
Along with 3.
Here, total 4.
Total 4.
Page 27.
Page 27. That is the forwarding letter to the GAD. GAD department will select the person. So Deputy Commissioner has forwarded the all application along with the ACR to the GAD by letter dated 30 September 2021.
30th September.
Lordship. Lordship will find Ratul Talukdar. 1.
Yes.
Rohen Boro, Imbeswar Boro, and R. Malakar. I am 4. R. Malakar.
Yes.
2 and 3 has not submitted and withdrawn from the candidate after filing application.
Yes.
Now remains Lordship the 1 and 4. Ratul Talukdar and myself.
4 is you.
My case is based on 2 things, Lordship. The Ratul Talukdar has been selected and appointed. Now I will take a Lordship that Ratul Talukdar is not SC 15 years of service on the last date of filing application. Lordship will find
years of experience is not there.
No, did not have.
How have you
Look, page 22 is a gradation list of SN engineer. Okay,
22?
gradation list of employees of the amalgamated establishment of Deputy Commissioner Nalbari. Lordship will find my name is serial number 4, Ramoni Malakar.
Yes.
Lordship got it. My date of joining is 21/2/1991. 4. 5, Lordship. Field number 5.
Okay. Yes.
Ramoni Malakar. Date of joining 21/2/1991. Now I will take you to page 22A. That is the gradation list of amalgamated Deputy Commissioner Baksha. Ratul Talukdar, 2.
Where do you get date of entry? 21 to 91 is date of entry.
Lordship, date of entry into service.
Oh. And where is Ratul Talukdar?
Page 22A.
A.
Ratul Talukdar, sectional assistant. Date of entry as a junior assistant, 26/2/2007. Page 22A, serial number 2.
26 to 2007.
2007. Without going to that aspect of the matter, Lordship kindly see the affidavit of the Deputy Commissioner, Baksha. They have admitted
Who is for R5?
Lordship will kindly see page 30 of the affidavit of the Deputy Commissioner Baksha.
Yes.
Page 30, look.
Yes.
Paragraph 4. As regard to statements made in paragraph 9 of the writ petition are matters of record, deponent does not admit anything which is not borne out from the record. Petitioner is put to strict proof hereof. Deponent beg to state that Assam District Ministerial Assembly Schedule 1967. Year means English calendar year. In the amendment,
Where are you reading paragraph?
paragraph number 4. They take it another plea that is well.
Page 30.
31. Paragraph 4.
By Anil Kumar Das.
Lordship.
Paragraph 4 is
Sanjeev Kumar Sharma, Lordship. Page 30.
that is 35. R3 and 4.
R3 and 4.
Page 35.
Lordship. Before that, Lordship, affidavit of respondent number 2, which is the GAD, Lordship.
Yes, sir.
GAD's affidavit is important, Lordship. Page 30, which is selecting authority. Page 30. GAD's affidavit, page 30, Lordship. Affidavit of
What do you want to show in
so before that, Lordship, kindly see affidavit of GAD, who is selecting authority.
page 30?
Page 30. Affidavit of respondent number 2.
Name of deponent?
Name of the deponent
Yes, yes.
Anil Kumar.
Yes.
I'll take your Lordship to the page 32, para 8. With regard to the statements made in paragraph number 9 of the writ petition, answering deponent humbly beg to reaffirm and reiterate the statements in paragraph 7 of the affidavit in opposition, would further like to state that it is admitted that as per concerned service rule, a candidate must have 15 years of service experience. But it is not mentioned in the advertisement, the candidate should have attained 15 years of service on the date of application. Therefore, since the candidate respondent number 5 has attained more than 15 years of experience on the date of selection of the board meeting on 29 July 2022, board accepted his candidate.
Please read again.
As per service rule, a candidate must have 15 years of service experience. But it is not mentioned in the advertisement, the candidate should have attained 15 years of service on the date of application. Therefore, since the candidate respondent number 5 attained more than 15 years of experience on the date of selection of the board meeting on 29 July 2002, board accepted his candidate. Lordship is aware the last date of filing application. Before that, Lordship, I will take your Lordship to the last date of filing application.
This is case process.
Case law. Lordship, 1997 4 SCC page 18.
1997.
4 SCC page 18.
Paragraph.
Paragraph number 6.
Yes, name.
Name of the Ashok Kumar versus Chandrasekhar.
Paragraph 6.
Paragraph 6.
Yes. Please read. Give an extra copy.
Lordship.
Can read slowly.
I can give.
That is the only issue. Tell me.
Look, 2 issues was there, but not necessary. Maybe
Yes,
also.
yes, yes.
Lordship,
These are sensible. What are
Lordship, first of all, I'm appealing for the CAD department. Lordship, here, as per the affidavit filed by the respondent number 5, the date of joining is 24/6/2004. So, Lordship peruses page 37 of the this affidavit was filed by the respondent number 5.
Yeah.
As if your Lordship peruses the affidavit filed by the respondent number 5.
number 5.
5, that is page 37. I'm just placing the fact because Lordship on the last occasion.
37.
Yes, Lordship. Here he has joined.
There's some.
He is joined on 24.
Wait. This one was 5. Name.
Name, my lord. Ratul Talukdar. Just filed on.
Ashok Kumar.
It was
We have
filed on
already given this.
15th February.
We have Ashok Kumar. Atul Talukdar is number
5. It was filed on 15th February.
yes, page 55.
So, Lordship.
Page 50.
Yes, fine.
Yes.
Yeah,
By
so here-
R5. R5.
R5. So here R5 was asked to basically file this to get their thing. There was a contention between both the parties on the last occasion. So then they filed this Lordship on 24 June 2004. He joined his service. His service.
Yes.
So if your Lordship 24, if we count from 24 June to the date of last application, which is 18/1/2022, the application was there. So if on that date, if we count both these dates, 17 years, 6 months, 24 days that R5 gets. That means he is above 15 years. Now, if we read 8.1, your Lordship may have this book, the assigned service manual. Page
Now, is there any dispute with the position of fact, with the contention that R5 not meet the eligibility requirement of
15
having
years.
15 years of.
My lord, here we're looking at this affidavit which they filed. Looking at this.
No, you're not going by the affidavit.
My lord.
You had made a stand
My lord.
that you had taken the date on which you have actually accessed the candidate, not the last date of the application.
Lordship, one thing I want to just say before this, my lord. Rule 8.1 is specific, Your Lordship. Persons served at least 15 years in any deputy commissioner's establishment and having working experience. Now, my lord, here, two things have to be seen. He is always harping on one thing, Lord, that is the 15 years. When we look at the rules is 15 years, we have to read it in co-jointly with the ACR grading. That is why the ACR grading on the last occasion, the Lordship asked me.
These are matters of selection.
My lord.
This is an eligibility.
My lord.
You need to have 15 years, means 15 years as on the draft date of the
Yes, he has 15 years. He has 15 years.
And
Because
why have you written that part in your affidavit by R3 and by R2 at page 30? The GAT, your department, at page 32, paragraph 8. What is this explanation, Mr.
Lordship, here we have just given the thing that my lordship 15 years is required.
15 years when?
15 years.
You have
mentioned
said
that
that the candidate attained more than 15 years of experience on the date of selection. We are not bothered with the date of selection.
But as per rules, Your Lordship, the person has to have 15 years.
Yes.
And
When?
So from it.
When? 15 years when? That is the question.
From the date of application.
If you have
From the date of application.
on the date of the application,
Yes,
did he have experience 15 years?
Yes, Your Lord. As per this thing.
Then why is this statement? Why is this submission? That he had 15 years on the date of selection. That is the
and
your answer to paragraph 9. Let us see paragraph 9 of writ petition. Come to paragraph 9.
5 of the writ petition.
Yes. The categorical statement has been made on the last date of filing of the application. R6 did not have 15 years. And he said that he had at the date of selection. That is not the requirement. If you have a selection after 5 years, will you count 5 years?
Lordship, 5 years, 15 years plus Lordship the ACR grading. As per the ACR grading also last time they saw.
Then you are going to some issue which has not been issued.
My lord.
We are on the eligibility part.
My lord.
First you have to have 15 years of experience.
15 years, my lord, from 24/6/2004 to 18/1/22, 17 years, 6 months he gets the Lordship.
When was he appointed? When did he join the service?
He joined the service on 24/6/2004.
24/6/2004. 2004. When was the advertisement?
Advertisement was 18/1/22. 18/1/22. 18/1/22 was the advertisement.
Now they want to project Lordship the honorary post held by him.
No, advertisement is of 17/12/2020.
Sorry, Lordship, 17, this thing.
12,
my apologies. 17/12/2020.
Yes.
But on the
17,
so here it's given a Lordship that application stating name.
When was the last date?
Last date 18 January 2021.
18 January. Here it's given a Lordship to proper channel. Application stating name, age,
18 January 21.
21.
Last date.
Last date.
21. So he completes 16 years.
But in the gradation list, Atul Talukdar, he joined on when?
21 to 1991. Sorry, 26 to 2007. 2007.
If your Lordship uses the affidavit filed by them, they have annexed document. Kindly check the annex.
2007.
You will see the page 55.
Of
page 55 of the affidavit filed by respondent number 5.
R5.
R5. He has joined from
R5 is
Ratul Talukdar. He has joined from 24 June. Page 55.
Document.
The document of office order. 24 June 2004. 24 June 2004.
He did not come into the cadre.
He said add.
But your lordship, if your lordship
Honorary
sees
post.
the rules, if your lordship sees the rules, lordship sees, I would like to, because this contention came up, that if your lordship sees the rule, 8.1, the Assam Services Manual rule,
Carrying the same
same book, lordship, I think,
page
page 198, your lordship.
198.
It is the Assam Ministerial District Establishment Service Rule, 1967.
Yes. Yes.
Rule 8.1. Rule 8.1A. 8.1A. A. Lordship, not thing 8.1A of the page 198 of the Assam Ministerial District Establishment Service.
Page 198.
Yes, my lord. In my book. 8.1. B. 8.1A. May I take it out?
Eight.
Post of administrative officer shall be filled.
Yes, yes.
Yes, my lord. Here the rules, my lord, is says that the post of administrative officer shall be filled up by selection from amongst persons who A have served at least for 15 years in any deputy commissioner's establishment and having working experience of different branches in general. Lordship will note this in general and in the establishment branch in particular. Now, your lordship, in this nowhere it is mentioned, it is only mentioned 15 years of service. Plus, your lordship, co-jointly having possessed graduate degree in any discipline from a recognized university in India. Now, your lordship, in this case,
Yes.
in this case, 15 years is to be counted from 2000 here. In this case, your lordship, if from 2004, that is 24/6/2004, this person joined. 18/1/22 is the at last date of application. Automatically 17 years he complete. But your lordship, in this, two more things are there. I mean, one more thing is there. Along with the 15 years, we have to also see the ACR grading, because on the last occasion I had brought the records, I had projected the records in front of the court also. In terms of the merit, the R5 is not qualified.
You are sufficient senior
My lord.
to know the difference between a eligibility and a criteria for appointment. You have come to a zone of consideration, you have the eligibility.
He has, my lord.
Why have you gone to the
My lord,
question of HCR?
15 years, my lord. He has.
You have concentrated on HCR. What is the question? What's the list about? He is
24.
making a specific allegation
My lord.
that the private respondent does not have the eligibility criteria.
My lord.
He may be high on HCR. They are not bothered with that.
My lord.
First, he has to be eligible to be considered.
My lord.
Does he have 15 years of service?
He has.
You say that he has 15 years if it is counted from 2004.
Four, my lord.
So you have concentrated your argument that the service of the respondent of 6 from 4 to 7 has to be counted.
Yes, sir.
On this, have you prepared yourself?
Lordship, on this lordship,
This
24.
ad hoc service or kind of honorarium service, will it be sufficient to be counted?
Because your lordship, the rules, it's specific. It's not mentioned in the rules, my lord. It says 15 years in general.
Oh, that is your argument.
My lord.
That is your understanding.
My lord.
I'm very sorry. There are so many cases. What occasions ad hoc service can also be taken into consideration?
My lord, on the last occasion, the record was asked. That's why, my lord, I
They are not bothered with HCR.
My
On
lord.
merit, he may be good, but he has to come into the zone of consideration. Advertisement says, rule says 15 years of service. Contention has been said that if you count the services from the gradation list,
My lord.
he joined on 26/2007 on a substantive capacity.
My lord.
You say that 4 to 7, he had also worked on honorarium list,
My lord.
and there is a letter. And your contention in your affidavit is not supporting your present submission. You have tried to justify that no, on the date of election, he met 15. He may not have met 15 years on the date of advertisement. You have not dealt with the honorarium part at all.
Your lordship,
If you want to say that we had counted the honorarium period, if justify us that maybe it's the same kind of service or something, there's no justification in that. Yes. That's all. What is this kind of appointment that is 24/6/2004? Please read your appointment letter with your banking account 24th of June 2004.
Yes, my lord. My lord, the second paragraph will be important.
No, please read the entire
Yes.
paragraph.
Sri Ratul Talukdar, son of Gopal Chandra Talukdar, so and so was working temporarily in the office of the CCF Wildlife, is hereby engages computer assistant come stenographer at a
Mutually agreed
agreed
honorarium.
honorarium with effect from 15/6/2004, subject to the condition that the engagement purely temporary and subject to the termination at any stage. However, he may apply for such post to be considered as per existing rules and procedure. Well, the next paragraph is very important in this case. The engagement must necessary at this as this is the new office without having any officer, and other than the undersigned, also not a single office staff. Since the BTC has provided computer and expert and experienced operator would be a better position to handle the workload of more than one office assistant, which will help in the new office to start functioning. That's the new district staff. My lord, the next page, my lord.
Yes.
He has been allotted other work also. He is the only staff in the office. Next page, my lord.
Yes.
Yes. There is a, with reference to the above, I have the honor to authorize Ratul Talukdar computer assistant come stenographer in the office to collect the ceiling under the head account of so police logistic support. His president secretary so. Then next paragraph also. These also 2004. He was allotted more work matter. For a smooth function of the different office, the following work allotment has been made. This order will come into force with immediate effect until further order. The last one is his name, Ratul Tar computer, all computer related work, all other work allotted by the district. Then next 2006 also, his process work on my lord for regularization, my lord. Annexure D, my lord, subject regularization to the Lower Assam Commissioner. With reference to the above, I have the honor to state that the DC office at Baksa district is being run by only 4 redeployed assistants, which is grossly inadequate. In this connection, I had already requested for transfer of new transferred a few posts from Nalbari, Borpana,
That would not be
district.
necessary.
Yes, yes.
What would be relevant to for us to decide is what's the meaning of serving for at least 15 years?
Yes, my lord.
Serving in temporary capacity, will it be sufficient?
Yes. One more thing, my lord.
Come to the rule.
Yes, yes.
Read with the advertisement.
Yes, yes, yes.
Advertisement is at page 20.
Yes, yes, my lord, advertisement, my lord. My lord, before that, my lord, this rule 4 and 5, I like to lay before your lordship. It indicates, my lord, status of the service and the strength of the service under Assam Ministerial District Establishment Service 1967. That is 4 and 5. 4 states that the status of administrative officer, revenue officer shall be that of class 2 gazetted ministerial service, and other members of the service shall be class 3 non-gazetted ministerial service. Next is very important. Strength of the service. The number of posts, permanent as well as temporary, under each of the categories mentioned in the rule, sub-rule 1, 3 shall be as such as may be determined by the government from time to time. Well, this is, I like to mention before that existence of temporary staff is there in the, that is one of my submissions. That is one of my submissions, that temporary staff can be there under the rule by law.
saying that will not do. There are schedules to this rules. You come to the schedule. Schedule 1 is how you select the candidate. Schedule 2 is very important. It says about the different posts under the establishment of the deputy commissioner and give the scale of pay.
Yes.
Unless you get scale of pay, you are not encouraged into the services. The initial service which you rendered in 2004,
Yes,
that was not an encouraged service.
yes, but this 15 years experience in the department, it's it
The department the
can
role,
be looked into that.
the advertisement, we can for the
Yes, yes.
can accept that give calm back. But there is a statutory rule which says about service. And if the rule says about service, we have to go what the rule means, what service, what is the meaning of service under the rule. There is schedule 2 which is gives the various posts. And all the posts have got scale of, you are not getting scale. Page 207 of
Yes, sir. Yes. My lord, your worship may allow me 2 days time, my lord, to see
why?
from 2004 to 7
You know what,
for
you know what
consideration.
is the dispute about? You come prepared. That day, it only talks about experience. I have gained the experience, so that cannot be a criteria. You have not, it's not even your
Yeah, my lord, I was that, my lord.
and this has been, if anything was there, it has been demolished by the affidavit. They said that they have counted your experience as the date of selection.
Yes, that
is not the correct.
yes, that is the mention from the substantive post, substantive joining, where I join on.
That is not even the place. Case. You're trying to.
Yes,
Mr. Stephen is trying to build up another case. It's not there in the beginning.
But my lord, it is a matter of record and fact that I was working from 2004, my lord.
But
That is there, my
can
lord.
we count that?
Yes, my lord, 2 days time, my lord, I will try to satisfy if I can. Since he has already joined and working, my lord, and also with regard
Yes,
to
sir.
my
With up to
father,
2020, 30 also. I have only 3 months of service.
that cannot be ground, my lord.
And he is
Now,
taking the benefit.
by now, we have also completed.
Now,
After December, you can very well be appointed. Okay, tomorrow.
Fine.
One. Also, if sending council is present, number 6.
Resolution number 5, my lord.
5. Is for further. Will dispose this of.
My lord, my lord.
So they given some time.
My lord, my lord.
obliges.
Just which matter? Just
Series. I think
one series has been taken. What time has been taken?
45 onwards.
Okay, oh,
ACC employees.
no. Three, 9. It takes 42. These series in between her that has been shown.
Yes.
You are in 40.
Am I item number
43.
my number is 53, my lord. Otherwise, there are
Part of
other
the
matters.
series. Part of the series.
Yes, part of
What are these matters?
what had happened in this case, the petitioners, my lord,
You
earlier
can take
they
your
were,
case to the lead case.
there are, as far as I am concerned, we are appearing in 4068 of 2023.
Other counsel, can you take this to the lead case? Is it similar?
Otherwise similar. Some fact.
No, fact. Okay.
Item number 60 also. I'm very
STC. So last you were there.
Lordship, I am there, but in this matter, we are being led by Advocate General.
He is not there.
Yes.
Is he there? There?
Yes, he is there. He is in court number 1.
We don't know about the continuation of this bench. So, can't wait till tomorrow. What is this? What?
My lord, the issue is, my lord, this petitioners, my lord, they're working as security guard under the different, my other Assam State Transport Corporation. Earlier, my lord, this work was, outsourced to certain security agencies, and we are all working under that security agency. Subsequently, my lord, the Assam State Transport Corporation took a policy decision that henceforth they will have their own security setup. So what they did, my lord, process of interview was initiated, whereby, my lord, the petitioners were working under those security agencies, my lord, they were recruited. They were recruited on, of course, on contractual basis.
By the STC directly?
By the STC. No, by different divisions, the selections were made.
Under the STC.
Yes. Now, my lord, the STC has taken what they have done, my lord, they have released us from our job. In one case, there is a stay order. Now, the reason is they say, my lord, while engaging us, due process of law was not followed. That is again not correct, number one. And number two, my lord, now what they would like to do, they would like to go for regular recruitment. But in the meanwhile, my lord, they would like to replace us by another set of matters. So that is the case, my lord. In their affidavit,
Even if we say that regular appointment is not barred, at least till first time.
till first time we should know, we should be continuing.
And you have to be given scope
Exactly.
for participating.
And from their affidavit, my lord, it clearly emerges that they would like to replace us by another set of contractual employees.
Mr. Nayak, you will be acquitting.
In this case, we have already filed our affidavit.
I'm saying from the affidavit.
Most of the petitioners have also filed a reply, Lordship. These are for disposal of actual. So, Learned Advocate General is appearing right now. He is on leave.
You tell us that when.
In fact,
But
my
is
lord,
it a fact that you will be replacing by temporary?
No, that is
no, my lord, I think my learned friend is not properly gone through. They have filed one affidavit, my lord, which they say they will rely on all the cases. So they have filed the affidavit in 3422 of 23. A copy has been given to us, and we have filed a reply. If your lordship would kindly have page 95.
3433.
Yes.
No.
3422 of 23. And to
Item number?
3422 of
What is the item
23. 46. If your lordship would kindly come to page 95, my lord. The first subpara on the top.
Yes.
In this regard, it is pertinent to mention that a meeting of the Board of Directors, that is 185th meeting, held on 24/5/20, yes, 24/5/23, wherein the board granted approval for engaging security assistant on short-term basis to security agency manpower as resolved in so and so as a stopgap arrangement. It is one
that is a decision for outsourcing, Lord, not engaged to be engaged by the ASTC themselves. That decision for outsourcing.
in effect, my lord, until regular selection is made,
No regular.
that is,
there
this
no
is
question
what
of
they
reg-
propose
these
to
are
do,
not
my
a
lord.
Contractual employee, and the authority has decided not to extend the contract beyond a certain period of time.
Just like that.
My friend will do. I'm not with you. Whatever happens.
I can have it.
Yes, Lord.
What happened?
This your president duty will accommodate to anybody.
Because from morning I was doing a matter, Lord. It is still part of it.
No, one thing which is propped up, we may ultimately say that there is no restriction for you to go for a regular appointment recruitment process.
If so need, right.
If there is, but till such time, there is also sufficient need from appears from your affidavit that you are trying to replace them by another temporary setup.
That is not correct.
You,
But affidavit-
page 95.
That is in respect of security personnel, we are giving some agencies to do, not directly we are. When the security persons are removed, we must,
Have some security.
yes, so agency has been engaged. Just like we have housekeeping agencies in High Court. We are not recruiting
Now, do
directly.
you have the copy of the board minor, the 184? Because it refers to 184
Board meeting,
meeting.
yes.
I think that will make sense.
My lord, if they now want to give to the agency, then why that system was done away with?
This is only respect of security person, not the other persons. Very few.
Okay, well, tell us, Chaudhary,
Yes, my lord.
tell us
Next week, my lord.
whenever.
Thank you. Will next Thursday be inconvenient, my lord?
Thursday, Deepika. Thursday, I am not here, Lordship. 30 and 30. Either 28 or Lordship, 7. 28 or 29th also I can.
Next Tuesday.
Next Tuesday. Next Tuesday. 29. If the clarificatory affidavit is required, I will file it.
No, your that minor 184.
Oh.
Producer.
Yes, it's the security agency, manpower agency. Very clearly we have said.
Heard. Other case.
No, there is no stay.
Security.
In fact, my lord, these are very recently have filed, my lord. The Honorable Court issued notice and tagged the matter with the matter where the state has filed.
Please give a list of. Also heard the current council or that the matter can as the affidavit filed in 3422 would cover all.
And we have filed
as-
rejoinder
as
also.
the is common. It also transfers that reply affidavit that is filed by the petition. This, as agreed by the party, this for admission hearing on
29. Sorry, I am
28.
29.
29 Tuesday.
29. 29.
28.
29 Tuesday.
No, I'm here.
No,
20.
no, 28.
I have no difficulty, but I have to continue today's argument in court number
Well,
1.
accommodate you.
No difficulty.
Anyway, my lord, we have got several councils on this side because we'll take some time. By that time, my lord.
28 then. 28. Correct interim order if any. That got connected.
Highly obliged.
Only one, if not.
If any.
If any. My friend is very conscious.
I will not cause president.
Highly obliged.
Yeah, please. There is a development here, your lordship. The communication which was issued earlier.
Here for the corporation.
I am for the corporation department.
Yes, sir.
Here for the petitioner.
Yes, sir. So I'm for item number 50, 51 and 52.
What to do?
Lordship, the salary has been released, your lordship.
Yes.
Communication has been. Your
That was the issue.
Yes.
Yes.
You withdraw it then.
No, lordship, no.
So lordship,
This is matter, lordship.
there is a series, your lordship. So there are 4 matters here, and the 5 matters have come up in court number 3, your lordship. Lordship, if I may place this communication
No, if the salaries have been released, that was the only issue.
That was the issue, Your Lordship.
Then,
That was the
is there anything to be aggrieved of?
So I have to obtain instruction, Lordship.
Are you aware or not?
Yeah, I am aware, Lordship.
That salary has been,
Yesterday they have informed me, Lordship.
then what? Tell us your prayer.
Yes.
For release of salary.
release of salary.
We'll close this and we'll give you liberty that if in case there is any such
Yes.
issue later on, you can come.
Yes.
What are these communication, impute communication?
Is it
23 and 21 3?
page number 40, Your Lordship, the impute note.
What was done by them?
So what happened? There were irregular appointments, Your Lordship, and there was an inquiry was held in 2015. And 2022, the report was submitted. And thereafter, Your Lordship, an order was passed to stay their salary. Some illegalities were found. They were appointments were irregular.
Those were these orders
Yes.
by which salary was stopped.
And this order is there. It was there was no termination of their employment, Your Lordship, but there was a order was passed, communication was issued to stop their salary. That is at page number 40, Your Lordship.
Not to disburse the salary.
Not to disburse.
Okay, then
Subsequently, Your Lordship,
you are in all the cases.
No, Lordship. I am for 51 and 52.
Mr. Gogoi, Sir Gogoi, J. Patwar.
Anurag Gogoi, Your there.
Sir Gogoi, J. Patwari. P. Datta. Anurag. The Bora, can you call them? One of them.
Lord.
First time, some
That matter.
first content.
Next week.
After some, I think.
They're not, Mr. Roy is from therefore, yes, yes, sir.
But
Therefore, Mr. Roy.
Yes, my God.
Yes. Not on.
It's coming.
Is anything?
Yes, sir. Discuss. Last time Lordship was authority.
Have it next week. Today we there's some installment.
My lord will take 31st, my lord.
On the request of the party. It's not 31. Yes, where is Mr. Nath? And Mr. Monto, we can complete that man. Gogoi, your, no, doesn't matter. Your grievances have been addressed. The salary stop order you have held. Now you have been given the salary. We will give you liberty when adverse.
But there is a, the without inquiry under rule 9 of appeal rules, they have stated that my appointment is illegal.
No, that those are not subject matter of self. Let them say that we'll give you liberty. Now this question was only for salary.
Unless until this the impugnator is set aside.
See, there now your grievance was what? Against 2 orders by which your salaries were stopped.
Yes, sir.
Now your salaries have been paid.
Only salary, but the without inquiry under rule 9, the fee is mandatory in nature. They have stated that there is a illegal appointment. But our
Let them hold the inquiry. We cannot preempt the.
let them have an inquiry under rule 9. This is depends.
Let them have it. Why should we advise them?
But
if they do not follow 9, it's good for you. See, this grievance, the impede of this writ petition, which was only with regard to the salary part.
Salary and illegal appointment.
Where? Let us.
Page 42.
Which petition? 6930.
3690.
3690. Page 42.
42. In inviting a reference to the subject cited above, I am to say that the undersigned has initiated an inquiry upon the allegations of illegal appointment, Gate 3 and 4 posts under the establishment of Deputy Registrar of Cooperative Societies, Nagaon and Tezpur. And on security of the matter on 8/3/23, it was found that the following employees have been working under the directorate since long, having invalid appointment orders and without regulating the services. They got salary on regular basis till there. Therefore, you are requested not to disburse salary of the concerned employees until further order. Under invalid appointment.
Now see, the Registrar of Cooperative Society, without holding an inquiry under the Rule 9 of disciplinary appeal, they cannot come to a finding of this. If they come, so you have all the right to tell. But now this penalty, the objective of this commission was to pull back your salary.
And to this, there is a finding of invalid appointment. But our appointment is regular because some of the employees have even got promoted.
We will clarify that position.
Even got promoted. There will be stigma on the part of the.
You give the list. You are appearing. And it's a bonus.
I have for 51 and 52.
Give it. How to as also
49 and 50. 49 and 50.
Give a chart.
49 and 50.
What for?
51 and 52.
Also had to be that the selling of cooperation. Demand raised by the petition in these are common, and in view of the similar which have taken place, which has taken common, these repetitions are taken up for at the end. Further by nature of development common which would indicate in this order common a detailed narration of fact and the cannot be necessary. The basic response of the petition in this case is with regard to communication between 320 and 21 issued by the Cooperation Department. No,
by the
Registrar of Cooperative Society, Assam, and District Deputy Registrar of Cooperative Society. It appears that petitioners who were appointed in grade 3 and grade 4 under various establishments of Deputy Registrar of Cooperative Society, especially in Nagaon and Eastwood, where it appears that there were certain allegations with the manner of appointment of the who are employees in grade 3 and grade 4 posts under the establishment of the Deputy Registrar of Cooperative Society, Nagaon and Eastwood. It further transpires that a preliminary inquiry was, and there was a prime finding of findings which were against the petitioner with regard to the validity legality of the report. On such consideration of the efforts, impugned orders were issued direct withholding of tax. Sri Rajpal, the Senate House, however, has informed this court that salaries have been paid to the petitioner, and therefore the impugned order by which such salaries were itself have not adhered. He according to submission that there may not be time for the victim. Yes. But on the other hand, of both Sri Gogoi as well as Bora have some, and apart from those that though the ultimate objective of the impugned order was to withhold salary from, there are certain observations on legality of the appointment which could cause prejudice. According to this submission, that unless the orders are set by cannot say that there is no life path. After considering submission and the development which have taken place, namely that salary of the petition have been reached, and in fact not being a disputed one from this court's view, that interest of the would be served and the equity would also be balanced if the petitions are closed with an observation that unless the due process of law is followed by adhered to rules governing the field with regard to declaring, with regard to declaring the appointments of petitioner to be well, the petitioner could be entitled for that. Further from since the salaries have already been released from us. Ineffectively, there may not be any further issue with that. You have the above. No. You have the above. And you have the are good. However, that in case of any adverse event, could be a and closer of cannot be cannot be deemed- cannot come to be cannot be a bar for such action.
And except will be effect, will be effect to and except 12.
They all both these connections number 12. So there are two connections.
12 and 13.
All right. Are
Obliged.
yes.
My lord was perusing my lord page number 32 of the writ petition. My lord, that is a communication, my lord, from the judicial department to the office of the accountant general.
Yes.
My lord, so far as my lord sanctioning of posts are concerned. Now there, my lord, at page 33, lord, will kindly see, my lord. Page 33 of the writ petition for a moment, my lord.
Appear for
My lord, I appear for the finance department here, my lord, the respondent number 1.
R
R1.
Yes.
Page number 33 of the writ petition. So this appears to be, my lord, the only handle on the basis of which, my lord, the writ petition seems to be founded. Because here, my lord, it appears that the government has let out a promise. At page 33, my lord, the last paragraph, lordship will see.
Yes.
There is the sanction.
Yes, he was.
My lord.
Yes.
My lord, these two office memorandum, my lord, the first one, my lord, is dated 3/7/2015. That is the OM, my lord, which has been referred to at page 33.
Yes.
And also, my lord, the OM dated, my lord, 4/9/2015.
Yes.
Now, lordship has both the OMs in my lord, with my lord.
Yes.
The first one, my lord, the 3rd July 2015, it only speaks about, my lord, about the delegation of powers. So as to, my lord, with regard to, my lord, the concurrence of the finance department is concerned.
for filling up a post. Yes, I am reading it, my lord. 3/7/2015. It has been brought to the notice of Finance Department that in spite of clear delegation made by Finance Department, some empowered authorities are not exercising their power in the matter of permanent retention of the post. It is hereby reiterated that Rule 1B of Schedule 1 of DFT Rules 1999, as amended, empowers Administrative Department to issue renewal of sanction for staff originally sanctioned with concurrence of Finance Department for 1 year at a time for 5 years in respect of post, including year of concurrence. While subsequent delegations made by these departments OM number so-and-so dated 6/3/1978 and 15/2/1980, 37/1984, 13/11/1997, and 15/12/1998 empowers appointing authority to issue permanent retention of post subject to certain conditions contained therein. To overcome the impediments in receiving salaries regularly by state government employees, the following further simplification is made. All posts created with prior concurrence of Finance Department and Planning and Development Department, both under plan and non-plan head, will be of permanent nature and no further retention will be necessary, excepting the post of temporary nature, sanction for specified work and for specified period, and should not be against any centrally sponsored team for the specific period. Then number 2, the posts which are not against any scheme and which are taken up purely on experimental measure or on an ad hoc basis. This will come into force from the date of issue of this memorandum. Now, my lord, this OM speaks of, my lord, retention of the post. Earlier, my lord, for every retention for every 5 years, periodically, my lord, the administrative department concerned has to obtain concurrence. Now that has been relaxed. It only speaks about, my lord, retention. No concurrence is required. But this OM is absolutely silent, my lord, with regard to that OM dated 2012. That means that the embargo created under clause 8 of that OM, that no sweepers should be directly appointed in regular basis, it should be outsourced. That has not been disturbed by this OM. And the second one, my lord, will find, my lord, that 4th September 2015, this is only a corrigendum, my lord, with regard to the earlier OM, my lord. In reference to the Finance Establishment BOM dated 3/7/2015 on the procedure to be followed for retention of posts under various schemes categories, in the said OM it was stated that it will come into force from the date of issue of this office memorandum 3/7/2015, which should be read as this will come into force from the date of issue of this office memorandum, and it shall cover the period from 1st March 2015 to 2nd July 2015. So this is only a, my lord, corrigendum with regard to the period. Now both these two OMs, my lord, have been referred to, my lord, in that, my lord, communication made by the judicial department, my lord, the judicial department to the accountant general at page 32 and 33. Now here, my lord, I have gone for the affidavit. I had a talk with Dean, senior advocate. In the affidavit, my lord, filed by the judicial department, a particular statement has been made that approval of the finance department was obtained. My lord, it is a wrong statement, my lord. At nowhere, my lord, there is no material on record whatsoever produced to show, my lord, that concurrence or approval of the finance department was obtained, my lord, for regularizing this post, my lord, the post of sweeper. And therefore, my lord, since it is the admitted position that once it was, my lord, the petitioner hearing, he was selected, my lord, no dispute, and he was, my lord, appointed his joint service, my lord, for release of salary, my lord, a proposal was sent to the finance SIU department. That is, my lord, the staff inspection unit department. Now they have rejected simply because of the reason, my lord, that OM does not allow. So this is how the matter stands. My lord, had it been the case, my lord, that there is an approval of the finance department, I could not have resigned, my lord. So a promise is not laid out, my lord, by the government, by the finance department, my lord, relaxing clause 8. Now here, my lord, one another, my lord, communication that has been annexed to the writ petition, my lord, it ought to have been brought to my lord's notice. But it hasn't been, my lord. Lordship will kindly come to page 25. This will throw some light, my lord. Page 25 of the writ petition. This is a communication, my lord, from the Register Administration of this Honorable Court, my lord, to all the district judges The subject is, my lord, recruitment of staff in subordinate judiciary of Assam. Here, my lord, with reference to the subject cited above, I am directed to inform you that the Honorable Committee for centralized recruitment of officers and staff of subordinate judiciary and all benches of the High Court in its meeting dated so and so resolved to allow appointing authority of certain establishment to complete the recruitment process already underway for the post mentioned herein below so and so. If no embargo has been put up any court, no recruitment is made where inquiry is pending. Then the next page, my lord, will find page 26. Further, the appointing authorities of all the districts of Assam are to fill up the vacancies of grade 4 post of Chokidar beyond sweeper is there, my lord, driver, record arranger, orderly, and mali, as well as promotional post of Ferristada, head assistant, upper division assistant, Nazir, and supervisory assistant on their own. And it says that on their own. So accordingly, this has been followed. So district judge Tirang, my lord, has been delegated with the power. He has, my lord, duly exercised that power. Now the question remains, my lord, who is going to pay the salary? Since the petitioner here in, my lord, is not a regular cadre, my lord, under the government of Assam, my lord. He is not under the, in any, my lord, regular cadre. So therefore, my lord, that is the difficulty on the part of the finance department. Permanent retention has been cancelled. Permanent retention, my lord, in my respectful submission, my lord,
Well, that's not a question of submission. Has it been cancelled? Matter of fact,
no, my lord, that, my lord, of course, my
it has been cancelled.
my lord, I do not have any knowledge on that.
Whose office memorandum has got not taken into consideration. Memorandum of 12. They are not bothered with 12.
My lord.
They are permanent instead of 12. There is this notification. They are not bothered with the OM.
Well,
notification conveying the sanction of the governor for permanent retention of post.
My respectful submission will be, my lord, this could not have happened.
And your promise, you are talking about the promise. Can you just say that promise of finance department is not there so that the end of the matter?
No, my lord, there is one another, my lord.
You can speak in two voices.
No, my lord, Lordship will kindly appreciate, my lord.
Tell us what is the way out. As an officer of the court, tell us what is the way out. A sweeper is performing his duties since 2016 continuously without salary. Is it the outlook of a welfare state by any means of standard?
No, my lord, my respectful submission will be, my lord.
For the sake of opposing, you'll oppose.
No, my lord.
Give us a solution.
Here, my lord, the judicial department, my lord, at the most, my lord, will have to pay the minimum of the pay scale, my lord, in at par with the dictum in Upenda. Because, my lord, this appointment
is this an illegal appointment?
No, my lord.
How can you expect Upenda with this?
No, my lord, he will.
This is valid selection process.
No, selection process. But, my lord, it beholds the, my lord, office memorandum, my lord.
How does an office memorandum be above the rules?
No, rules, my lord, this is selected, my lord, but his OM still stands, my lord. His OM has not been interfered with, my lord, by any court of law.
Part of the OM, the judicial department has said you go ahead with the retention.
Retention.
It was held in front of your eyes.
My lord.
Yes, Mr. Nath, anything else?
No, my lord, one.
Come up with some practical solution. If there was any fraud involved or any anomalies involved, that would have been different. There is a selection process. A court is involved. He is serving. Till date, it has not been outsourced.
Absolutely, my lord, will kindly consider
At
my
one point of
submission.
time, we thought that it will be given fixed salary. Now, after the retention, we are not even at that. It will be full salary. Yes, Mr. Nath, anything. It's up to you. You can share the service. We'll not comment on it. We'll not comment on it.
Yes, my lord, one decision, my lord, if I may place, my lord, lordship. My lord, this is, my lord, reported in Monopatra, my lord. My lord, this is order dated, my lord, 27/5/2011, passed in WPC 3087 of 2010. 27/5/2011, my lord, passed in WPC 3087 of 2010. My lord, it is.
Which court?
My lord, by this honorable court, by this honorable court, my lord, single judge,
My lord, it is Subansiri Kuibatta Mean Palan Self-Help Group. Here, my lord, one handle has been given, my lord. My lord, at paragraph 21. My lord, if there are difference of opinions, difference of views between two departments of the government, then this court has the, my lord, power to relegate the matter, my lord, to the chief secretary, and the chief secretary will take a decision, my lord, in consultation with both the departments. You may kindly peruse it. We have. Yes. That. And my lord, the provisions of AFRBM Act may also come into play here, my lord. The Assam Fiscal Management Budget, my lord, that is a statute, my lord. There, my lord, at section 7, my lord, clause B, my lord, it is stated, notwithstanding any other provisions contained in any other act or rules, no new post shall be created in any department of the state government or in autonomous bodies, including private sector undertakings, companies, statutory bodies, societies, cooperative societies, which are under the state government without prior concurrence of the finance department. Here, no new post to be. No new post will be created without concurrence of the finance department. The creation of a new post. No, my lord, this is retention. It's a creation. No, it is retention, but my lord, I am drawing an eligibility, my lord, because since my lord concurrence of the FRPM for a post of a sweeper. Not even it is not created. It's an old post being retained. It is retained. And you have said that for retention, don't bother us. You do it on a road, you already administrative. Yeah. So this has been done, but my lord, the only hurdle, my lord, that I may place before this honorable court is that. Yes. I am aware.
Well, in fact, Lordship, I have indicated the stand taken in the affidavit, but it is also there, my lord, that the retention order was issued. They have in the affidavit itself stated that as per approval. Lord, I have telephonically asked them where is the approval, but since Lord, Lordship is hearing the matter, Lord, they said that they have to examine. Otherwise, in the in view of the stand taken in the affidavit, paragraph 8 and Lord, that 13, the office memorandum is found. They have to follow the office memorandum. They are binding. Office memorandums are binding, and this sweeper post as on today has to be approved. And that is the view. That is the stand taken. But the retention has been come by. You go for outsourcing. Lordship, in fact, I go for outsourcing. If you want to. Yes, my lord. Then you go for outsourcing. In fact, during my discussion, they said that if the outsource, the whatever is payable to the outsourced people, if that proposal comes, my lord, he can be paid that amount. Because ignoring the office memorandum, two office memorandums, my lord, he has been appointed. And how this 4/11/2015, my lord, they said that they will. Right.
4/11 are you doubting?
So 4/11, my lord, in view of the office memorandum, in fact, they should not have. Otherwise, the post of sweeper is not. The victim is the petitioner.
Anything else?
Other submission is during the discussion I have heard, no further submission is required before, as I have submitted earlier, relying upon the division bench decision of this honorable court, whereby I have cited the division bench. My lord, I have কিতাপখন দিছিলো কি কৰি কেলে সিদিনাখন যে দিছিলো আপোনাক 2007 GLR. Yes, my lord. This honorable court in division bench has clearly, your lordship may peruse it. In the office memorandum which has been referred to.
Lordship, I have a small question. With you, at 3:30, there is a special reason and
No, doesn't matter. No, we have heard. Good for you. Yes.
My lord,
Paragraph.
your lordship may peruse the head note is very clear. I am reading Constitution of India, Article 235. The High Court exercises control not only in respect of the judicial officers, but also in respect of ministerial and subordinate staff working under the court, functioning under the High Court. Petitioner appointed as peon in the office of the district and session judge. Salary of the petitioner not paid for want of concurrence from the department, finance department. High Court alone has the jurisdiction in respect of the appointment of the writ petitioner. Insistence on concurrence of the finance department of the government of Assam or payment of salary held to be an unauthorized intrusion into an area over which High Court exercises exclusive control. This is the principle led by this honorable court in such circumstances. Other withdrawal of a person who has been continuing in a retained permanent retention retained post. Withdrawal of the salary is an punishment to the other. He cannot be discharged without or terminated, or salary cannot be withdrawn. Otherwise, without due process, going to the due process of law.
Or also very enough. Consider which is not a of salary just for sweeper to the people establishment of this not is the date of birth there now consider that contest aside the instead at the however for going direct conflict to have back if the district judicial establishment that Tikira that establishment of the district of Tira was when was it started?
My lord.
Tira?
Tirang is annexure 1. Your lordship may peruse at page. At page 20,
At page 20.
was done
Yes, ma'am.
year 2007.
Seven.
By the communication issued by written but government was dated 31 of sanction of governor of Assam for creation of 100 numbers in the PS created shooting that of Iraq was with there were three numbers of sweeper, four establishment as well as establishment of chief executive. The committee for centralized of officers of subordinate had taken a which was conveyed to all the judges, including that of Iraq by communicated 5 and for the vacancy, including the post of Pittsburgh. Pursuant that the district judge Iraq had a request of by a committee well made issued DIPR from Assam for publication of the advertisement newspaper. The advertisement also included one post of paper, the same paper. The state section for the paper. The meantime, the judicial department of our government had issued communication dated 4/7 conveying the section of governor plus the permanent resident of one numbers of which include three numbers of each of the courts of Udal, Kamasya, and Top. The state notification had also referred to office number in the of bank, but it 37 and 49. With regard to the comma, petitioner was issued a call letter dated 2/11 to appear for driver was scheduled on 9/12. Stage selection of the petitioner was selected for the post of sweeper and husband was appointed by 57. He supported the person that had clearly expected that such a person was against of action by the government on 21st of September. The case of the petition that pursued the order has joined served and has religion. However, because he is not received out on photo the council has submitted that appears that salaries have not been due of an office in 2012 as per which the sweeping and filter were cut down to he submits that state were issued by the vice president would not be applicable instead and most of people which the president as Iran as government state and still did no decision taken to outsource the work of people in the court. The council has also submitted that under Article 35 of the comma, the High Court exercised control of service related matters, not only of care officer, but also of ministerial and support staff. And therefore, an act by administration would amount to the with power of the High Court. Regard the Council has referred has relied upon passed by Honorable Division of Court reported of the 3 KLR 240 per contract of Dina Director represent the Judicial Department has submitted that the OM did 33 outside is presently hold the field and in paragraph 80 it has specifically held that the work of sweeper is but the output and that the present process would not have been held. The further sub that though a subsequent poem was issued on 6 except the high and subordinate court from that records, comma, such except is only with regard to clause and clause 7 and not and has not and has not diluted the requirement of clause. According to some that not affect when he also submit that the recruitment side as such could not have been completed after completion poem dated 30 and that the post of sweeper could not have been filled up. He has also referred to a communication dated 25 March 2017 by the State Department. Whereby clarification has sought from learned with regard the mode of the arbor depending on finance has
So there is no doubt that permanent selection of the post was made by nomination in 411 comma. In view of embargo made by the office memorandum dated 33,012, comma, the present could not have. He submits that in the retention order of retention order dated 411, though there is reference to OM dated 3/7 and 4/9, comma, those M are not relevant, and the most relevant OM dated 3/12 has not effect submit that to invoke the doctrine of provision of there has been a clear and in case of there is no such problem. Right? Whereas as by proposition to an order dated 7/5 of this code, every 3087 state is common. It is subject that a situation where there were different of two departments common. The matter was one to chief secretary of state for resolution. The board facility has also referred Assam FRBM submit that creation of without the sanction of SI is not permitted. Also, the legislature, however, has contested, has however not supported the defense of right as well as he submits that the petitioner was stuck in the procedure by a validly conducted recruitment process. He contests that first the post in question has permanent, which was created as permanent which was formed by government in 47 submit that you have such a scope of outsource job of that could not have arisen. The senior counsel predecessor that the OM did 33,012 would have no application. Those where the post of it has permitted and in addition to that no step been taken till now. Outsource the job of judge, comma, the claim made by the petitioner appears where court has duty custody the rebel and counsel the issue involved appears to have arisen from the office for 30, whereas the petitioner has stated that going ahead with the recruitment in spite of such office is clearly indicates the fact that the office memorandum was not the version of judicial department as the finance department that the recruitment could not have been gone ahead. So, but in view of clear policy notified by the OM in 2012, whereby the post of was the outlook and to resolve the controversy. Honest to the background and fact that before such recruitment process was by the advertised it should by the district judge through DIP. The advertising has been done keeping view
direction of committee for centralized officers and staff of the contact, and also the fact that the post which was created by created created as communicated by latter dated 31/3/2007 was permanently retained as communicated by latter dated 4/11/2015. The sanction of the Governor of Assam to such permanent retained clearly mentioned about the post of recruitment involved in this, and such permanent retention has been done despite existence of the memorandum of 12. The state, the state communication was also marked to the finance department and was issued by the judicial department. The matter would have been fully different if, in spite of such retention, the work of people was output, which, however, was not done, and rather, in view of such purpose, a recruitment was initiated in which the petition was duly checked and according appointed by the appointment order dated 8/7/16. Even the state appointment letter mentioned that the post was sanctioned by the government on 31/3/2007, and as observed above, such sanction was followed by permanent by communication date 4/11. So the forfeiture that are standing on the finance part has tried to argue that the permanent extension of the post has mentioned two office memoranda of the finance department dated 3/7 and 4/9, which are not connected with the OM date 33/12 with regard to the aspect of output from such argument cannot be read in view of the fact that, in spite of he said OM dated 30th of Feb, comma, the permanent petition clearly contains the post of sweeper, which is the post which the petitioner has duty of. The matter would also have been would also have been different if there was a fault in the recruitment which does not appear at all, and rather the recruitment process is preceded by the prescribed preceded by the procedure prescribed law, whereby advertisement was made through the DIP, and after a duly conduct of the petition has appointed, the learned district judge has also supported the validity of the appointment. From the aforesaid fact, it transpires that while the recruitment of the petition to the post of sweeper was done on the strength of creation of the year and its permanent by of its 7th. Comma, the salaries have been set only by the court. The officer dated 30th Feb. This court has also been apprised that till date the post of has not been out to the concerned established has been in the concerned established of the judge dinner, and it is performed. But it is the central law that the that 2 weeks of the government cannot have inconsistent and it can the recruitment was initiated pursuant communication of permanent dated 4/11 issued by the district court, which was also intimated to the final court. Till now, no step have to implement the policy regarding the job of as notified by OM dated 30th Feb in concern established And therefore, in the considered opinion court, comma, the therefore considered unless there is a definite step to implement state part of the OM dated 30th where the concept established from the salaries of the patient in the case notified cannot deny such observation of court is also modified by the fact that till date there is no step that state to be taken by either the state to be taken by the defendant or the part to cancel the permanent retention of post in however, without even going into to that aspect of the present action of denying salary to the who whose job is that of a trip is has to be totally unjust and totally unfair. A court accept or for that matter, any accept cannot consider and without taking that aspect to consideration from a wholly approach as taken by the authority, which this court deprecates. Sir, it is according to direct sir, this is not allowed by direct the both the administrative department department and the finance to immediate to take immediate steps for release of salaries from both arrears and current to the petitioner. Such as is the petition is deprived from its salary for the last 7 years, it is direct that it have forced the direction for release of it complied immediately and within an outer limit of what have been written for
Mal. Obliged. Law.